Good afternoon, and welcome to the Appellate Division, First Department. Yes, there are 4 justices in the courtroom. But let me say that Justice Gonzalez is participating in today's argument, but she is not present in the courtroom. So she will participate in today's argument, but just not present in the courtroom. Now, today we have over 8 hours of argument time requested. So, as I call the calendar today, please only request the time, not that you want, but the time that you need to make your most salient arguments. Now, I assure you that we have read your briefs and are familiar with the underlying issues of your appeals. For those of us that are with us for the first time, the white light on the lectern will go off when you have 2 minutes left. Or if you've requested less than 2 minutes, it will go on immediately. When the light turns red, that means your time is up. Now, if the panel has further questions past your allotted time, we will keep asking questions, and then you will have an opportunity to respond. So when I call your case, please rise, tell us who you represent, and how much time, not that you want, but the time that you are requesting. People versus Brian Brown. Submitted. Valarezo v. HP Jamsta Housing. All right. Good afternoon. 414. Kay Leone is submitted. Deutsche Bank versus Roberts. Let me find out if they have questions. Any questions? Okay, submitted. Thank you. Board of Managers versus 45 East 22nd Street. Okay. How much time were you requesting? All right. 52525. Rodriguez versus RXR Glen Isle. Well, the appellate. I don't think we have questions. Thank you. People versus Chad Gardner. Submitted. People v. Jason Picaro. (515) Gilbert versus Winston. All right. 525. Acevedo versus City of New York. All right. 515. T. Hayden. All right. Okay. And who do you represent? Because there are 2. The agency, okay. And the attorney for the child will be submitted. All right, so that is 5-3 for the agency. The other respondent submitted. People v. Rafael Silva. All right, 5-5, thank you. People v. Vasquez, that is submitted. Masumi versus Ganju.
Good afternoon, Your Honor. John Williams for Appellate Cyrus Masumi, 6 and 2.
Uh-huh.
Respondents request 6.
All right. 6-6. Bellotta versus A.O. Smith Water. All right. 5-5. Labby versus Cummings. Mm-hmm. All right. 5-1, 5-1, 6. Thank you. 1946 Tremont versus Nawal Realty. 5-5. Semiauto versus Method General Contractors. All right. 4-1-3. People v. Sharp. All right. Submitted. Thank you. People v. Johnny Marin. Submitted. And 237 East 20 versus SD 2nd Avenue, that's also submitted. Let me say that we are going to call 3 cases out of turn. The first case that's going to be called is number 16, then followed by number 5, followed by number 9. The reason why I'm going out of turn is because for the first case, number 16, Labby versus Cummings, Justices Kapnick and Scarpula are recused, and Justice Chan is being vouched in. And then with respect to numbers 5 and 9, that is Board of Managers, and Gilbert, Justice Kapnick is also recused, so rather than the back and forth, let's get it all done in one shot. So the first case up is Labby versus Cummings, and Justice Chan is being vouched in. Ready.
Good afternoon, Your Honors. I'm Judy Shametsi from Wilson Elster, here for Dr. Varma today. As I know Your Honors know the record, I think the critical question here is not so much whether this patient is better off on Coumadin or Xarelto, but whether she's better off, before we know what ultimately happens, not in hindsight, whether she's better off on poorly controlled Coumadin or Xarelto, because she's clearly having an issue complying with the rather onerous requirements for Coumadin, and that is the only way to keep her factors properly under control, is to keep sending her for blood tests, keep changing the dose that she needs to take, and again and again and again, sometimes multiple times a week, but at least weekly. So
No,
this,
if I may.
yes, Your Honor.
It just seems to me that this is really about a battle of the experts, with respect to the two medications. Now, let's just assume that your client set forth a prima facie case. Let's just assume that. Why is it your contention that the detailed expert, submissions fail to raise a tribal issue of fact?
Yes, Your Honor, thank you for that. The plaintiff's expert's criticism is less focused on the care that was rendered and more a criticism of the literature. He is saying, based on the article that quite a bit shifted the landscape and the underlying research that shifted the landscape, because this is a new medication, he is saying this article is no good, this research is no good for this patient. So he's leaning into criticizing the underlying research, but that, respectfully, Your Honors, is not actually the standard. Well, of course, the entire community is waiting for this study, waiting for the new meds, waiting to see how it's going to go. The fact is that the community is embracing these medications and is using these medications. So responding to the fact that our experts lays out that the standard of care, the way that the hematological community is approaching decisions on drugs for patients of this type, that embraces now the use of Xarelto, because it is, if it works, a better medication.
Because the bottom line is that, you have two sets of experts, and let's just, stick with the plaintiffs that are saying, you know what, at the time, particularly, patients with APS in 2015, 2016, that it was Coumadin, that was the preferred, standard. And I think it was even your client that may have, and if I'm mistaken, please correct me, that I think it was your client that said that, yes, that was the frontline medication. That was the gold standard to treat APS when your experts say something different. So isn't that right there a issue? And let's talk about the fact that this study, and what the RAPPS study, right? That you have different opinions on what the study is, because one is saying, persons with the triple APS, they weren't even considered, in that study, and that you don't have enough data. You need, more research. So doesn't that, set forth an issue?
Let me, two very small corrections, and I do understand the gist of the questions, but I got to say it.
Uh-huh.
The study does include patients who are triple positive.
Okay.
No, there's no question about that. The second,
The question is it a significant number that renders the study reliable?
all due respect, Your Honor, that shouldn't be the question. The question should be.
Well, I know how you're framing the question, right? But isn't really the question here not the way you framed it, but isn't it really whether the prescribing of Xarelto at the time was within good and accepted medical practice?
That is
right?
that is the question.
That is the question, right? And based on that, what your side is saying is that based on the medical literature that was available at the time, that yes, it was. Plaintiffs is saying the opposite. No, it was not.
Actually, I'm saying based on what the community was, the community of physicians who are practicing in this area were actually doing.
Your experts commented on the medical literature, correct?
Barely. My expert mentioned the RAP study once, but that's not, the point that we make, Your Honor, is that the hematological community at the time was prescribing Xarelto for triple positive APS patients. That is the issue. The criticism to that, to respond to Your Honor also, the criticism to that we're hearing is, yeah, but the community was following this study, and this study has a number of weaknesses. This study is, of course, peer-reviewed, it had comments, it had all kinds of things. But the question is, did the community at the time embrace this medication for patients in this patient's predicament? And the
Let me
answer
say
to
that
that is
you can
yes.
follow up on that in rebuttal. So we're going to hear from the other
Thank you,
appellant.
Your Honor.
Thank you. You may proceed. Thank you.
Good afternoon, Your Honors. May it please the Court, my name is Timothy Gallagher of Shop Amity Citron Spratt on behalf of the other defendants and appellants, Dr. Sparrow Outpost and Lenox Hill Hospital. Your Honor, there's two issues here. The first part is the alleged departure, which, as my co-appellants have described, is about whether Coumadin or Xarelto was the appropriate medication. But there's also a causation issue here that even if Your Honors are not persuaded on the absence of a tribal issue of fact with respect to alleged departures, there is a tribal issue of fact with respect to causation. And what that is that my client's expert, Dr. Weitz, opined that the alleged injuries were not caused by by any anticoagulation medication. That really had no factor in the mechanism of injury. He explained that APS is a condition that also has cardiac manifestations, which can cause the formation of what he described as valve vegetations, which is basically
Is it your doctor's position, your expert's position, that this would have happened to this patient irrespective of whether she was taking Coumadin or Xarelto?
Yes, Your Honor. His opinion was that it's something that could have happened regardless of whether she
That
was
could
on
have
Coumadin.
happened, but that would have happened.
He said that it couldn't have been prevented by either medication. It's something that
So what's the point of prescribing the medication, right? Because I think we will agree that this patient is unique in that not only did she suffer APS, but she was at the higher level. She was at the highest risk, right? So now it's accepted today after the fact that Coumadin is the gold standard. So I'm not sure how that I understand your expert's position that irrespective of what she took, that this would have happened.
Well, Your Honor, the reason is because the expert explained that the mechanism of injury was not a blood clot. And that's what Coumadin and Xarelto prevent against.
Yeah.
So was there already some valve vegetation before she took the Xarelto?
So the prior study that she had was in June 2015. That was when she was at Mount Sinai Hospital for the pulmonary embolism, and she had a transthoracic echocardiogram then that revealed normal findings. And that was one of the bases for my expert's opinion that there was that it was this valve vegetation, not any kind of other cardiac issues. So that was the last study before then. So at that time, she's clear. There's no indication. But then when she has the heart attack in December 2016 and goes to the hospital, that's when they find this thrombus on the aortic valve. And the expert explained that her coronary arteries were otherwise normal. And that was one of the bases for his opinion that this was a valve vegetation and not a blood clot. And
Plaintiff's expert disagrees on that. So isn't that a classic tribal issue?
well, respectfully, no. Plaintiff's expert actually agreed that she did develop valve vegetations. That was one of the points in plaintiff's expert affirmations.
They may have agreed with that, but are they saying that was the cause of that the medication had nothing to do with it? I don't think they agree with that aspect.
You're right, Your Honor. The plaintiff's expert does disagree with that, but plaintiff's expert doesn't really refute the core point that medication has no effect on the formation of these valve vegetations. And that's why plaintiff's expert opinion ultimately is conclusory, because that's the key here, that regardless of the medication, that it's not going to prevent this. And plaintiff's expert basically just said that, oh, there's no scientific studies that support that, but then we provided those studies. So plaintiff's expert really didn't disagree with that core contention, and that's why on causation, plaintiff failed to raise a tribal issue of fact, because it really didn't dispute that the specific mechanism of injury that our expert identified is something that wouldn't have been prevented by either medication.
Well, I think the plaintiff's expert focused on the clot in the posterior descending artery and saying it was a clot, but he didn't really, so it wasn't a valve vegetation, but a blood clot.
Well, Your Honor, plaintiff's expert does put forward that theory, but again, that doesn't account for the fact that the coronary arteries were otherwise described as normal, which is something you wouldn't expect to see if there was a blood clot there. And that was a fact that Dr. Weitz, our expert, relied on in forming his opinion about the valve vegetation being the cause. So that's another reason why these alternative theories that plaintiff's expert put forward are really ultimately conclusory, because they're not really based on the same evidence or responding to the same evidence that Dr. Weitz relied on in forming his opinion. And the same goes for the other alternative theory the plaintiff's expert put forth, which about that this clot could have been present for weeks or months prior to plaintiff ever coming to Dr. Spiropoulos in June 2016. But plaintiff's expert doesn't explain how, if this had been present for weeks or months prior to then, how switching the medications could have prevented, her ultimate injuries. Doesn't explain.
Thank you, counsel. We're going to now hear from respondent.
Good afternoon, Your Honors. May it please the court, my name is Matt Geyer. I represent the plaintiffs' respondents. Before getting to causation, I just want to point out that the study upon which the defendants relied, including Dr. Varma, who never mentioned it by name but talked about a 2015 study, Dr. Spiropoulos, who mentioned it by name, was the RAP study. The RAP study was published in The Lancet in September of 2016, and it specifically states...
How do you respond to your adversary's position that it's not really about the studies, it's more about what was accepted in the hematological, hope I said that right, community at the time?
Right, so there's no evidence that it was accepted in the community at the time as Xarelto as opposed to Coumadin. The study itself, published in...
And that's because it was so new at the time, right?
Yes, but the study itself, published in 2016, states warfarin, which is Coumadin. Warfarin and other vitamin K antagonists are the standard of care for the secondary prevention of venous thromboembolism in patients with thrombotic APS. That states, the study upon which they relied for changing it, states that was the standard of care, Coumadin, not Xarelto.
I don't know if they relied on that study since they, the patient was prescribed Xarelto back in January 11, 2016, and Dr. Spiropoulos prescribed it in June 2016, before the study came out.
That's correct. So that was when the article came out. The study was performed in 2013 and 2014. By 2015, the study is being talked about. Dr. Varma talks about how she went to a conference in, I think she said, December of 2015. Okay, and she said the only possible study that could have been talking about the efficacy of Xarelto would be the RAP study. Dr. Spiropoulos was very clear. He's all about the RAP study. He told the plaintiff about it. He talks about it at length at his deposition. He misunderstood it because he said that the authors found it would be as safe and effective as Coumadin. They never said that.
Well, at that time, the plaintiff had not had her heart problems, the heart attacks or the stroke yet. At the time that she was prescribed the Xarelto in January and in June.
Well, that's correct. What happened was she'd had a prior thrombotic event earlier in after a prior pregnancy. She was on Lovenox, then she got changed over the summer to Coumadin. When she first got on Coumadin, they had to get the INRs proper. There was never any erraticness here. She was solid on Coumadin. Dr. Varma testified to that on page 5750 and 5755 of the record, that she was stable on Coumadin. So there's no issue that she was erratic. What Spiropoulos has in his note is just wrong. She was solid on Coumadin. Then when she comes in 2016, she asks about Xarelto. Dr. Varma changes it and says, based on a study that she heard in 2015, it would be as effective and safe as
How do you respond to your adversary's position that there's a causation problem?
Okay, so his position is based upon his expert, Dr. Weitz. Dr. Weitz comes up with this theory that it had nothing to do with blood clots, and that it was strictly a function of the APS that thickened the heart valves and vegetation. He says, my expert agreed there was vegetation. He did. My expert agreed there was thickening. My expert agreed, what he said is a sentence, thickening and vegetation. He said she fits that. Because she had APS, that's what you have, vegetation, nowhere in this record, nowhere. Dr. Spiropoulos and Dr. Varma both were involved in this patient's care after she threw the clots and had the MI and the stroke. Dr. Spiropoulos specifically asked about endocarditis. He said there's no indication of vegetation. That alone undermines Weitz's opinion about vegetation. On top of that, Dr. Varma specifically testifies at her deposition, because she came in and treated her afterwards, on pages 5740 to 42, clots on her aortic valve. multiple blood clots. Clot caused her MI. Whites disregards that. That's the evidence. Our expert embraces it. And what my expert's point is, even if there was vegetation involved, doesn't matter. Clotting was the ultimate cause here, and the clots were a significant factor, and that's why she needed to be on the appropriate anticoagulant, which was Coumadin. And had that happened, this would never have happened. She would never have
So
an
I
MI.
think that all of the experts agree that part of the accepted medical practice here would be to include and to consider the patient's wishes with regards to taking medication. And there's evidence here that she resisted Coumadin because it required weekly blood testing. How does that play into it?
So just briefly on that,
I'll let you, that's the last question.
yeah, and that's all I'm going to talk about then, okay? First of all, Dr. Varma uses the word insistent at her deposition. That's not what she put in her record. In her record, she simply put in that she would like to start Xarelto. Nothing about insistent. She transmogrified it when she got into her deposition and became insistent. Dr. Ram relied on it, totally inappropriate. Dr. Spiropoulos puts in his note that she didn't want to consider Coumadin. Now let's just see what happened here. She's already on Xarelto in January. She's going for a second opinion in June to find out if it's safe for her to be on Xarelto. Not to switch to it, she's already on it. How could she not be considering Coumadin if she's going for a second opinion as to whether to stay on it? On top of that, when you read Dr. Spiropoulos' testimony about the conversation he had with her, he talked about the RAP study, conveyed his understanding that it would be as safe and effective as Coumadin to go on Xarelto. And it's after that she says she doesn't want to consider Coumadin. That's not a fair or accurate representation to rely on that statement without taking the context that he told her it was as safe and effective.
Thank you, counsel.
Thank you.
Thank you.
Your Honors, let me just for a second circle back to the gold standard issue here. There is no question that Coumadin works, and it worked for her. The question is this patient, given her life, given her 2 young children, given her job, all of these things, is she able to maintain the regimen? And it is true that Dr. Varma testified she couldn't do it. That's why she's asking to be switched. We're not blaming her. It is the reality. It's a terrible medication to live with. It requires a lot of the patient. So if you have an alternative, and in that moment, certainly, the hematological community believed that it did, of course you're going to switch her if she can't stay
That's where
on
the
it.
devil lies. That's the detail, right? That's the problem, because you're assuming, or at least you're arguing, that at the time the medical community thinks that this is acceptable. And what the plaintiff is saying is there's no reason, there's no basis for that belief if you read the medical literature. So isn't that where the dispute lies?
Well, actually, Your Honor,
Because for you to be successful, you have to agree, you have to believe that prescribing Xarelto at the time was accepted in the community as safe.
if I may just quickly respond to that, Your Honor. Actually, Your Honor, the very literature that talks about let me do it this way. There are not just studies among the medical literature. There are case reports from hospitals who are giving this medication, and they're reporting on their experiences. And by the way, they say, we're going to wait for the RAPS. Everybody's waiting for the RAPS study. We're going to wait for the RAPS study. But my point is that they are giving the meds because this is what the community has in that moment. This is the best, most practical medication to give. And that is why she gets switched, in the hopes that this medication routine she can maintain. It is better than being poorly on Coumadin. Thank you,
Thank you,
Your Honors.
counsel.
Your Honors, just to respond to a few of plaintiff's points about causation. Respectfully, plaintiff's expert never differentiated when plaintiff's expert said that there was valve vegetation or thickening. Plaintiff's expert never specified that he was only talking about thickening as opposed to vegetation. And there is actually, even though people didn't, even though doctors didn't use the word vegetation in the record, doesn't mean that there's not evidence in the record that that was present. If you look at page 17933 of the record, the operative report, when the thrombus was removed from the aortic valve, it references the leaflets of the aortic valve being thickened. That's consistent with valve vegetation or thickening, right? And then the clot on the aortic valve is also described as being mixed with fibrous tissue. That's consistent with Dr. White's description of a valve vegetation. And plaintiff's counsel pointed out to Dr. Spiropoulos' comment about the absence of vegetations. So what Dr. Spiropoulos was referring to was bacterial endocarditis. So that's the kind of vegetation that would have bacteria in it. And Dr. White's explained in his definition of a valve vegetation at page 6297 of the record that what's different about the valve vegetations in the context of APS is that they're sterile, meaning that they don't have bacteria in them. So Dr. Spiropoulos' comment about there being no evidence of bacterial endocarditis doesn't rule out that there was APS-associated sterile vegetations.
Thank you.
Thank you, Your Honors.
Board of Managers of 45 East 22nd Street condominium. Ready?
May it please the court. I represent the lender for a construction project that constructed apartments in a building for sale, and an an affiliated defendant that had nothing to do with this transaction. Now, the plaintiff has sued the sponsor and the architect and other people for problems with the building. And they also have a suit of fraudulent transfer against my client, the lender, and Madison Realty, the other entity. These transfers fall into two categories. The first is the mortgage loan, the initial mortgage loan, and then second is payments that were made on that mortgage loan. I think we should start with the mortgage loan. The plaintiff attacks the mortgage loan basically relying on the fact that the sponsor used some of the proceeds, at least in part, to pay off equity. There's a problem with this, and that somehow the lender a secured creditor becomes preferred equity, because that's how the sponsor chose to use the funds. And in fact, there are no allegations that that anyone other than the sponsor made that choice to how to use those proceeds. There are other problems.
Counsel, let me just start you by asking you one. Have you received any repayment of the loans?
There were some repayments.
And what happened to that money? Did it pay the loan down?
It did pay the loan down.
How much? How much did you receive and how much of the loan was paid down?
It was
I mean,
well
isn't
less.
that the whole point here?
It is well less than the 100
plaintiffs are
million.
saying, one moment, that the plaintiffs are saying you're getting the money, but you're not repaying back the loan.
No, the plaintiffs alleged in their complaint that the principal balance from one particular payment did not decrease. And
Well, okay, so that is literally what I just said. So the
It's
question
not- the
is,
difference is
do you
because it
dispute
ignores-
that, right? And we're talking about a preliminary injunction. So given that allegation that you are not repaying the loan with the proceeds of the sales of the apartments, that raises some issues, correct? Debtor-creditor issues?
it would, except that the principal balance, all loans are paid interest before principal, and there's accumulation of interest here. And this project took much longer than was expected.
So again, the plaintiff is arguing, look, I was a bank lawyer, I get it. I know how
There's-
loans are repaid. You don't have to lecture me about
Right.
interest being paid before principal. What the plaintiff is saying is you're not paying back your loans. You're doing other, they are not paying back your loans. And that creates debtor-creditor issues.
With respect to the preliminary injunction, there were facts put in outside the complaint, which include the fact that with respect to that in particular, the payments mostly were made to a mezzanine lender, which is not a defendant here. Now, that's not, technically can't be considered on the motion to dismiss.
So let me ask you two questions then. One, do you disagree that once the money is dissipated or sent to whoever from this sale, that the principal defendant will be insolvent?
No, I can't dispute.
Okay, so, and two, you have the plaintiffs have been required to post a bond, correct?
Yes, Your Honor.
For $500,000.
Correct, Your Honor.
And the preliminary injunction has been in place for over a year, correct?
That's correct, Your Honor.
So where is your irreparable harm in this?
Well, the irreparable harm is that my client has loan-on-loan financing and is incurring interest every day.
Right, but
In
you have
addition, the
500, if
sponsor is
the
also-
preliminary injunction was improper, you've got $500,000 sitting there waiting to pay you back.
That will not compensate my client remotely for the amount.
So then go back to the trial court and say that the amount of the bond is insufficient.
We did try that, Your Honor, and that was denied.
Oh, okay, so that'll maybe be your second appeal.
If I may, I understand what Your Honor is saying, but the prior payment on antecedent debt is reasonably equivalent value. And there is nothing in the complaint which says that the payments were not applied as they should be. It's a misdirection to say that the principal balance, that's not the question. The question is whether the balance was reduced. They haven't alleged that the balance wasn't reduced.
Counsel, based on the allegations here, without a preliminary injunction, what would stop the further dissipation of the assets in light of the allegations?
Well,
What would
there's
stop
only,
it?
there is, if I may
Please.
answer. There is only, the last unit was sold after the complaint was filed, and that is the proceeds of which, about $12.5 million or so, is being held in escrow. But there's an architect who's a defendant who also has, I'm assuming has insurance to back it up. I don't know if the sponsor does. There are avenues for compensation here.
All right, thank you.
Please the court, Nicholas Yanuzzi for the appellant Ian Bruce Eichner. Essentially what it comes down to, Your Honors, is exactly what just happened here. This is a case about a construction defect case. It is a case about revenue from sale of apartments. My client is sued here as an individual. He doesn't own the apartment. The money that's being argued in these various transactions doesn't go to him. He's an
But I
agent
mean,
for the
the
sponsor.
plaintiffs are alleging that he has benefited from the distribution of the sale of apartments in a way that puts their being able to collect on this judgment, to the extent they get it, in jeopardy, right?
Whether they put it that way or not, the fact of the matter remains that they haven't pled anything to make him any more than an agent of a corporation.
Well, didn't they plead that the way that the loans were paid back and the way that they were structured and paid back was so that he wouldn't have to be liable on his direct guarantees?
The only thing that what they do claim is that there was an original loan and then there was a second loan that was taken out, and that he was a guarantor for that second loan.
And isn't the claim that he is no longer have to worry at the way that the money was dispersed and is being dispersed, he doesn't have to worry that his personal guarantee is going to be called?
Well, I would first suggest that in the complaint itself, the underlying complaint, the allegations are very sparse. In the respondent's brief, more details have emerged that now implicate my client even more than before, but on the actual motion, what they say is that he's the guarantor and that because they were able to not default on the loan, that he's benefited. But he's benefited as
that's
much
the
as the building is benefited because they didn't default on a loan.
But well, except that the building, right, has the property. Your guy doesn't have the property to satisfy the loan, right?
Correct. My client has nothing.
So he's got even more interest in it. We're only talking about the debtor-creditor law here, right? So the question really is, are you adequately protected? Because the bottom line is, finish discovery quickly, go to trial. The bank's still going to have its loan. If the bank has its loan, and even if the plaintiff wins, the bank's secured loan is always going to have priority over the plaintiff's claim. The plaintiff is an unsecured creditor. So the only question is whether you're adequately secured.
The fact of the matter is that we appealed, this was a partial motion to dismiss against the two fraud claims, and that the plaintiff did not plead properly plead the heightened standard for these fraud claims. My client we did not appeal there's a third cause of action for a fiduciary claim against my client as the board member, but the fraud claims are the ones that we're here about because those are the claims that they didn't meet the standard that they were supposed to meet. They didn't meet the heightened fraud claims. They didn't meet the heightened claims to pierce a corporate veil. They say he signed the offering plan. We have cases to say just signing the offering plan doesn't change you from just an agent and make you personally liable. The same
I'm
thing.
curious, what was Mr., is it Eichner, am I pronouncing it
Yes.
correctly? Okay. What was his control over both, the sponsor and Madison?
Eichner, first off, has nothing to do with Madison. Madison's a separate company. Eichner is a agent of the sponsor, but he's a corporate member of the sponsor. He's not the sole member. And if you read the papers of the plaintiffs, the pleadings, they claim that Madison's the one in charge. They vacillate back and forth as convenient for them to say Madison's in charge, Madison's taking the money, Madison moves the money. Oh, but also Eichner's completely in control too. And then in the respondent's brief, they start they pad that claim. It's not in the complaint, but they pad that claim to say, ooh, essentially the sponsor was cut out entirely. This was just Eichner. This was just Madison. This has been a whole cabal the whole time. But the fact of the matter is, they want Madison to be in charge, and then they want Eichner to be in charge just so they can keep him in the case. But at the end of the day, he's still just an agent. He's still just part of the sponsor entity, the corporate entity. And to pierce this veil, they have not met their standard to do
Has
so.
the lender called the loan?
To be honest, Your Honor, I have very little to do with the loan. That is mostly for the sponsor and the Madison.
Well, doesn't
defendants.
your guy guarantee
So
it?
you're right, Your
Oh,
Honor. So
yeah,
no,
you have a lot to do with that loan.
Yes, Your Honor.
So
Yes,
you know, and let me ask you
Yes, but
again, has the lender called the loan?
yes. My understanding is that the lender has not called the loan.
So even though the lender just argued to me that, and all of us, that the loan was in default and they weren't getting their interest payments, the lender hasn't called the loan.
I don't believe so, Your Honor,
Okay.
but I would defer to other parties.
Okay.
Good afternoon, Your Honors. May it please the court. Michael Beck from Schwartz-Sladkis for the plaintiff respondent. To pick up on your point at the end there, Your Honor, that's kind of exactly where we are, is that they did not call the loan.
But if they did call the loan, they'd be a secured creditor. So, I mean, it seems to
That's-
me that if they want their money, they want their $20 million, call the loan. And then you're an unsecured creditor, and sadly for you, you will get what you will get, but the
That's-
preliminary injunction is not their problem.
That's correct, Your Honor, but that kind of goes to the whole fraudulent scheme here, is that Madison came in with a loan, guised as a loan, but essentially took over for the sponsor and became a subsequent sponsor without taking any of the responsibility of what a sponsor would have to do. That said, we put in the preliminary injunction emails from the managing agent where he was CC'd on them, showing that Madison was not acting as simply a lender. They were negotiating the finer deal points for all the sales, for the sales of parking lots, parking spaces, for the sales of storage units. They were seeking to get not just monetary issues, but we need a sign off on a 50-pound dog, which is over the limit for the rules of the condominium.
Well, what is your claim for fraudulent inducement against Madison?
We don't have a claim
I
against
mean,
fraudulent
I'm sorry, against Eichner.
Mr. Eichner signed the sponsor certification on 3 or 4 separate occasions, including once the building was substantially complete.
So is it your argument that he is personally liable for breach of fiduciary duty, or for what?
There's several different claims here. There's 6 causes of action. In terms of the fraud in the inducement claim against Mr. Eichner, by signing the sponsor certification, and there's case law we put into our briefs that says by signing the sponsor certification, he has put himself out there. He's not simply just an agent of the sponsor. He is the sole principal of the sponsor pursuant to the offering plan and the amendments. At that point, he certified that the offering plan has no material misstatements, no factual inaccuracies, and at that point he knew of, certainly by the last one, he knew of the issues.
You're saying
with the
he
condominium.
personally participated in the fraud?
Well,
That
the
he himself personally knew of it?
The fraud at that point is selling units to unsuspecting purchasers, knowing that there are issues in the building and knowing that they are not buying what they bargained for. So that, Your Honor, is the fraud. The fraudulent conveyance is a
No, I mean, that might be the fraud against the company, but you're saying that he personally knew, and not just by signing, because the law is not that just because you sign on behalf of a corporation that you're personally liable. You're arguing that he personally knew?
Yes, Your Honor. Our argument, and we pleaded with specificity, that he knew of or should have known of all these construction deficiencies because he was involved in the project from start to finish. He was the sole, as I said, the sole principal at that point. If not him, who would know better than him? He's the one who was intimately involved. He was signing off on the sales. He was personally involved in all of those aspects. Therefore, we brought a fraudulent inducement claim against him.
Well, I mean, maybe his architects and everybody is telling him this building looks great, this building looks fine. That's what I'm saying. What specificity have you proved that he personally knew that it wasn't? Are there documents that you've looked at that show that someone is telling him there's a problem and he ignores it or doesn't respond to it?
Well, I believe, he certainly knew these things. He was also the sole.
Well, I know you're saying he knew, but I'm asking you what facts are you pleading
He was
to
the
show it?
sole board member for the sponsor-controlled board.
Again, how do you know that all his architects and everybody else isn't telling him, no, this is great, this is good?
With
How do you
respect
know
to,
that
to,
he
to
didn't
one
he knew
aspect,
that?
the building maintenance unit, the BMU, which is a $5 million custom built for this property, it never worked from the beginning. He was the sponsor board member who was supposed to, as the board, supposed to be fixing it. He knew of that issue while they were still selling more units. That in
Telling
and of itself,
everybody that it wasn't an issue.
telling everyone everything's fine because the offering plan says this is part of what you're buying is a specially designed building maintenance unit that goes down the side of the building. It's actually right outside if you want to go look at it. Right, and it goes down the side of the building and it cleans everything and it allows the efficient maintenance of this building. He knew about that. He also knew of there were leaks in the waterproofing of showers throughout the building, and this goes kind of goes into the breach of fiduciary duty. He put that through the building's insurance rather than fixing it from the sponsor aspect, but he knew of these defects. He personally, because he was the board at that point. So certainly he knew of those defects when they were still selling units at that point.
Okay, may I ask one more question about the bond?
Of course.
It's $500,000. What's the interest on the loan?
The interest on the loan, I'm not 100% sure of off the top of my head, so I don't want to speak out of turn.
Well, where'd you get the $500,000 number?
From Justice DeAugust.
What did he say was the basis of the $500,000?
I believe only after the fact did the Madison defendants bring up that it should have been larger. It was never argued for the amount of the bond at that point.
Is there a record on how the number came up?
I don't believe so, Your Honor.
Okay.
Thank you.
If I can address your last question first. In our brief on page 44, we point out that the collateral lender is owed $3,319.10 per day.
That's default interest, right? That must be default interest?
I don't know the answer, I have to admit. That's the
Okay,
amount
let me ask you, why haven't you called the loan?
The reason we haven't foreclosed on the loan is because remember, the only assets here were apartments that were being sold. And as long as that was happening, foreclose only would have delayed things by years as we wind through the foreclosure.
You want the $20 million, call the loan. That's the only thing you've got left is what we're all hearing. Call the loan. So that also leads to a reasonable conclusion that you're not calling the loan for a reason that is not above board, or that in some way you are in collusion with Mr. Eichner, or in some way you are hurting your own ability to collect. You're the secured lender.
Foreclosing on the loan while the unit sales were, unit sales is basically the only.
It's done, the sale is done.
I
That
understand,
money's in
but it's
escrow.
subject to a court order already. I don't think that we can go into another court another court and launch a foreclosure
Why
on
don't you
funds
get a
that are already
judgment?
frozen.
Why don't you get a judgment which would have priority under over an unsecured claim. And the
We-
fact that you're
we
not
already
doing
have
that,
it. We already
counsel,
have
leaves more questions unanswered than answered.
Your Honor, we already have priority because we're a secured creditor. It's the proceeds of the sale of our collateral, so therefore the security interest extends to that collateral. And in terms of this fraudulent scheme, what incentive would my client have to loan $100 million, good portion of which went out the door on day one to preferred equity? This fraudulent scheme makes no sense.
Thank you.
Thank you.
Your Honors, on the issue of this offering plan, all the cases that are cited by the respondents, all of them turn on the one issue of there is a smoking gun that the plaintiffs in those cases have of there's an expert report that says this building is falling down and the person who signs the offering plan had it in hand when he signed it. That is not the case here. There's no expert report. There's no foolproof document that says this building is deficient
But
and
we're not on summary judgment time yet, are we?
we're not on, but they
We're
are.
still doing discovery, right?
Well, we haven't even gotten that.
Who
but
knows if there's a smoking gun or
The
not?
fact of the matter
We'll
is,
have
for a
to
fraud,
see.
for a fraud claim, it is a heightened standard
Well,
pleading.
he's made, the plaintiff, I shouldn't say he, the lawyer, the plaintiff has made a factual allegation that Mr. Eichner knew about the problems with this sleeve thing on the side of the building when he was signed the document and was selling units.
And I would also suggest to the court that, again, the furnishing of details of the nefarious acts of Mr. Eichner have come in only before this court and not before the motion court. The motion court, the term that's used constantly is the sponsor defendants. Eichner is used constantly in that claim, not of what he actually did, but just the sponsor defendants did X. And all of the claims are what the sponsor, the construction did, and not Eichner as an individual, who again is an individual and or an agent for a disclosed principle.
Right, but we're on a pre-answer motion to dismiss the fraud claims, right? And the preliminary injunction, two different things. But, I mean, that sounds to me like your argument is better for summary judgment, right?
I would disagree just insofar as, again, the law says the heightened standards, plead with specificity. The CPLR says for both the two ways that they're trying to get my client on these two claims are specifically told that you have to meet a heightened standard. It's not just the regular standard, particularly if you have to pierce the corporate veil to get an individual involved into corporate liability. Thank you, Your
Thank you.
Honors.
Gilbert versus Winston.
Thank you, Your Honors. Ari Silverman on behalf of appellants. Your Honors, the motion court erred in granting respondents' motion for summary judgment because it did not follow First Department precedent, which clearly requires courts to conduct individualized assessments of each of the individual board members before liability can be attributed to them for the board's tort. These are factual inquiries. The conduct, knowledge, and state of mind of the individual board members must be assessed, and the plaintiff bears the burden of proving that each of them knew that what they were doing was wrong. In this case, where there's allegations of bad faith, it's even more important that each individual is given an opportunity to defend themselves.
Also, in the prior case that we decided, which I was a part of, we held that the board acted in bad faith and therefore struck their answer, correct?
Correct.
In that case, Winston was also named, correct?
In his representative capacity, correct.
So there was necessarily, his answer was stricken as well, correct?
Correct.
So there was a finding that Winston, at least in that capacity, acted in bad faith, correct?
Correct.
Is he a stop now?
He is not, Your Honor. The claims asserted in that case were, did the board breach its fiduciary duty to the unit owner that was the plaintiff? The claims in this case are, did the individual board members in their personal capacity?
So you're saying that in the first case, Winston was in his professional capacity as opposed to his personal capacity.
Correct, and it's a different fiduciary duty. At issue in this case is a fiduciary duty owed to the unit owners in the condominium. So he's not stopped. In addition, there's no privity there because the backbone of privity is fairness. And Winston was not given the opportunity in the case below to explain why he did what he did, why he took the positions he took. This court in Fletcher v. Dakota was concerned with why. Not just what, but why. He was never given the opportunity to explain why, nor were any of the other 8.
Was there any discovery taken in this case?
Barely any documents.
None of the board members were deposed?
Not in this case.
So
and not in
none
the
of
case
them
below.
had the opportunity to even allege advice of counsel defense?
Anything. And had they submitted an affidavit in the case below in their personal capacity as a non-party with no charges asserted against them, had they submitted an affidavit to the court that said, Your Honor, in my personal capacity, I was relying on my counsel, the judge would have shrugged and said, okay, well, your counsel was wrong. It was a frivolous argument. And the board is found liable. They didn't have the opportunity. It would have just been rejected. Why are you submitting an affidavit as a non-party when there's no charge against you?
Right, they were not parties to the first, so clearly they didn't have any opportunity in the first action to argue whether or not their own actions or inactions were a breach of fiduciary duty, right?
Correct, and that's why their collateral estoppel was improper to be used here. And in this case, the only opportunity they've had to speak for themselves was on our summary judgment motion, when we submitted sworn affidavits and documentary evidence showing that the attorney was retained in December of 2020 to provide advice in the business dealings with the plaintiff, carried through until June when the case was commenced, steadfastly held to the advice that was given, and then in February of 22, the judge called the attorney to court by way of affidavit to explain the basis for the position. There's been no doubt, I'll point out, by the way, in the decision that was rendered affirming the original decision, this court acknowledged the attorney's frivolous arguments, as did the lower court. So all along this progression, the court recognized that the attorney was responsible, the mastermind, so to speak, who orchestrated all of this. Not the individuals.
So right now, we don't have any information about what, if anything, the individual board members did or did not do.
Before we submitted our summary judgment motions, no. Now that we've submitted our motions, we have sworn affidavits and documentary evidence showing that they requested advice, received advice, deliberated, and followed the advice. This is competent counsel with nearly 100 years of condominium law experience that knew this building, represented the building in connection with the dispute with the prior unit owner, so knew the settlement agreement that was at issue, the part of the governing documents, knew all of this. The perfect lawyer on the planet to advise them and represent them is who they got. And they followed the advice. There wasn't more that they could do. Get a second opinion from who? Nobody knew the situation better. So all we're asking for is our day in court. Give us the opportunity to assert our defense because there's no basis to stop us from doing so. I reserve the rest of my time for rebuttal, if I may. Thank you.
Good afternoon, Your Honors. I'm Richard Weiss. I'm here representing the plaintiffs and who are the respondents here.
Counsel, how do you respond to your adversary's position, which sounds eminently reasonable, that our finding in the first case that the board acted in bad faith doesn't translate into the individual board members?
Thank you, Your Honor. So if you look at the original decision in the underlying action, which this court affirmed, it is clear, and Mr. Winston's name is mentioned throughout, not just in a representative capacity. Nobody knows why he did what he did. He is called out by name for specific lies that he told about the $10,000 they never received. About
clearly there was bad faith on the part of the board. At least that's what we held, right? But again, how does that translate to the individual board members, unless your argument is solely to Mr. Winston?
Well, so there's two ways that you can get to all of the board members besides Mr. Winston, in addition to Mr. Winston, who I think it's clear there has to be estoppel for, because privity being what it is, fairness being what it is, he's clearly the ringleader, he's clearly the main actor. So I don't see, and you're going to have inconsistent decisions if you decide that, Winston acted in bad faith in this case, but in the case against him personally, Who can say whether Winston acted in bad faith? He has to, you know, everybody has to be proven against him for the first time, again, anew, because if a jury finds that, you're going to have an inconsistent verdict. Now, as to the other defendants, I think it's clear that
Why would that be inconsistent? He's not the board. Why would it be inconsistent to find that the board breaches fiduciary duty, but not the individual board members? That happens all the time. There's nothing inconsistent about that.
well, it would be inconsistent if let's say a jury in our case finds that no member of the board acted in bad faith, including Mr. Winston.
Why would that be inconsistent? Again, that's so, the board may have breached its fiduciary duty, but it's a different fiduciary duty each individual board member has. And two, one may find that the individual board members have defenses that the board itself wouldn't have, or would have asserted defenses that the board itself didn't defend. There's nothing inconsistent about that.
Well, respectfully, Your Honor, I don't see.
A corporation can breach a contract, but the president of the corporation doesn't breach the contract, even though the corporation president signed the document, said don't pay, does everything else. It's not inconsistent. So let's assume that we don't agree on that. What I want to know is, what do you have with respect to each individual board member showing that, what did you put in, because you made a motion, with respect to each individual board member?
So with respect to each individual board member, we have the court's prior finding that the board collectively acted in bad faith.
That's a
I know
different
it's not enough.
entity, right?
We put in the fact that none of them have ever identified any decision that they were not part of. We also have in the
burden? Isn't that burden shifting? That's your burden.
well, they cross-moved for summary judgment, and they put in all the papers that they had. Any
So
evidence?
again, what did you put in on your case? You moved for summary judgment. What documents and evidence did you put in on your case with respect to each individual board member?
With respect to each individual board member,
There's nothing. Isn't that the answer?
No affidavits.
we did not have affidavit. Well,
No-
we put an interrogatory request, and we asked them, please identify, you know, why you think you did not participate in the bad faith acts that the court found in the previous decision, and they refused to provide anything. Now, they raised some sort of arguments for why they didn't have to do it at that stage, but they didn't. And they still haven't put in
Again, you
anything.
moved for summary judgment before you took any depositions, before you got anything else. You moved for summary judgment based on the decision against the board.
Because the board clearly acted in bad faith and showed deceitful and
Counsel,
misleading conduct.
Counsel, the problem with your position, I think, is highlighted when you look at board member Beck, right?
Sure.
According to your position, Beck would be stopped.
Beck has been on the board since May of 2022.
She came on after your lawsuit was instituted.
Yeah, but at any point in time, Justice Borak below was telling them, hey, sign the PW1, get out of this lawsuit, approve the plans. Why are you still doing this? And that was the bad faith. So, and at any point in time, she could have voted, let's just sign the form. Let's just get out of here. Why are we persisting?
And did you put in any evidence that she did not vote that way?
No. There's no evidence that anybody dissented. Their position below, as I understand it, is we all acted in good faith. Nobody acted in bad faith. I don't think that's possible. I don't think it's possible.
How about all of them saying we relied on the advice of counsel?
So then, if everybody relied on the advice of counsel and everybody acted in good faith, then how is that reconcilable? And
Because
who acted in bad faith?
the board, through its counsel.
But counsel cannot act for the board. The board acts for itself on the advice of counsel. So who had the bad faith?
The board. It's a separate entity.
But the board is only composed of
You're
people.
pretending that the board doesn't exist. The board is a separate entity from the board members.
But the board could only act through its 9 individual members.
Thank you.
Thank you, Your Honors. In addition to the points that the bench made regarding failure to put in affirmative evidence on respondents' summary judgment motion. I'd like to point out that we made a prima facie case on our summary judgment motion that is appellants, that they
Again, there's no discovery. I don't know why anybody moved for summary judgment. You put the pleadings in and you cross-move for summary judgment with no discovery, without anybody having to test what they actually did, said, or thought.
We cross-moved after the original summary judgment motion was presented because we didn't have a choice. We couldn't just be on our back foot defending, and we had to make an effort, and we made a prima facie case, and then the burden shifts to respondents, and they put in nothing to rebut, refute what we put in, or to raise a material issue of fact. So we would ask this court to reverse the judge's order with respect to our summary judgment motion and grant that motion.
Did you cross-move
We did.
to
The advice of
grant
counsel,
the,
affirmative defense.
right?
Put in the sworn affidavits we put in.
No, on appeal,
I'm sorry?
on appeal.
This is my appeal.
Right.
I'm appealing.
Oh, but I don't think I saw you. Did you say and grant us summary judgment?
Yes, certainly. Reverse it entirely.
Oh, yeah, you're right. Okay. Yes, I'm sorry.
I want to, if I could, give a sort of a hypothetical, and I'm not saying this is what happened at all, but to further clarify the court's point about it is possible that the board was found to have acted in bad faith, and all of the individuals are not found to have violated their duties at all, let alone in bad faith. And that is, if one board member was the mastermind and convinced all of the other board members to go along with their plan, after this first department inquiry that must be done, that one board member likely to be found guilty, and the other 8 would likely to be found, or not guilty, but liable, and the other 8 would likely to be found not liable. Now, say it wasn't that one board member, and it was the attorney. Counsel is telling them, you must do these things. And by the way, after the case started, counsel that originally gave the advice informed the board, you should not deviate from what we've been doing. I think the direct quote is, the court will not look kindly on that. So it is possible that it wasn't one board member who gave, or any board members who gave this this direction and requested support, but it was the board, it was the attorney who did that. Then you have 9 individuals that are relying on counsel.
Thank you.
Thank you very much.
Valarezo versus HP Jamstar Housing Development Fund Company.
Good afternoon, Your Honors. May it please the court, John Shore for plaintiff appellant. The lower court erred when it denied plaintiff's motion for summary judgment when the lower court said that plaintiff failed to establish its prima facie entitlement to summary judgment. Actually, on 2 levels, plaintiff established summary judgment. Plaintiff's testimony alone established summary judgment. There is no requirement that there be a witness. There is no requirement that plaintiff need to see the.
And was your client's testimony rebutted at all by anybody in this case?
Absolutely not, Your Honor. Not only was it not rebutted, but the accident reports, which are admissible, corroborated my client's testimony. The accident reports, there
were three separate reports in this case, right?
3 separate reports. In fact, counsel relied on these reports. Not only that, counsel admitted that the VP from CNY, the GC, authenticated the CNY accident report, which A72 of the record says the rod fell when it became loose from the sling, which secures the drill rod in a vertical position. I mean, I'm not going to rehash all the other accident reports, but they're all consistent. Counsel argued that they're inadmissible. Not only did he rely on them, but he submitted them. And clearly, we're talking about a 9 to 10 foot, over 200-pound object that fell on plaintiff. And in fact, Kingdom's incident report said it was 600 pounds. And as this court knows, there are cases recently in this court, Argueda, Villanueva, and a recent one, Mustavach. In Argueda, we're talking about even poles that were not even elevated. They were leaning against the truck. And this court said the pole that fell was not secured. In Villanueva, we're talking about a similar type of object. It was about a 9 to 10 foot beam that they were trying to manually put into an elevator, and it banged into the top, and it wasn't even elevated, and it fell like maybe a half of an inch and struck the plaintiff's shoulder. Here, we're talking about a huge machine, and by their own admission, which is uncontroverted, that the sling, the apparatus that was supposed to secure this 9 to 10 foot solid metal beam that weighed over 200, if not 600 pounds, fell and struck plaintiff. There's nothing uncontroverted. In fact, they corroborate.
May I just ask you, are you saying that you didn't submit the documents that the defendant alleges contained inadmissible hearsay?
Oh, actually, we did
did?
submit. Oh, of course we
Okay.
did. Of course
So
we
that,
did. I'm
I just,
sorry,
I
Your
just
Honor.
got, you're saying, no, they put it in, because that wasn't.
I apologize. I submitted it, and they submitted it as well. Not only did they submit on it, they relied on it, and counsel's own admission in his papers, in his memo of law and his affirmation, what did he say? Mr. Grimsland authenticated the CNY accident report, which they relied on. Unless this court has any other questions, I'll rest on my brief. Thank you.
Good afternoon. May it please the court?
I am confused. You argued on your direct case, you argued these documents that on appeal you are now claiming contained inadmissible hearsay?
Yes, that is correct. What I'm saying is this, none of those documents have any statements from anybody with personal knowledge of the facts of the accident. That includes the CNY report, which he mostly relies on, and all the other reports. They are just an
But
amalgamation.
you argued that they were inadmissible hearsay.
I did,
but
yes.
So you waived that if you put them in on your own case and argue them.
But the plaintiff still has to meet a standard on summary judgment. It
Oh,
still
I'm
has to
not-
be
right.
with personal factual knowledge. That's the distinction, okay? It still has to be with personal factual knowledge. The reason why I indicated that Mr. Grimland authenticated the report is because that's what he testified to. I couldn't deny it.
You know, counsel, I don't understand how this height differential would be de minimis, you know, in light of the fact this is like a 200-pound, steel bar, 9 to 10 feet in length. How is this like de minimis?
Your Honor, I was not there. I don't know. I can't say that it's not de minimis. I can't say that it is.
The brief says.
Well, I'm not arguing that it's not de minimis per se. But what I'm saying to you is that the plaintiff did not satisfy his burden of proof. He has to come forward on a summary judgment motion with knowledge of a person with personal knowledge of the facts and circumstances.
He did. He testified.
He didn't see the action occur.
When the plaintiff testified that, this bar fell on him. What else do we need?
I mean, he wasn't standing and looking at it, watching it fall on him, if that's what you say. He was standing there working with a coworker, and the bar fell and struck him.
He woke up, he was on the ground, the bar was next to him. That's what he said. He didn't see the bar fall, any part of the bar falling, nothing like that. Nobody saw the accident. They could have deposed.
So what are you going to, what evidence are you going to submit in opposition to his testimony that he was standing about 5 feet away from the bar when it fell on him? It hit him, it knocked him out, he woke up, there was the bar.
You
coming up with you have another story for how it happened?
No, but it's not my burden of proof. It's his burden of proof. I don't have to come up
So
with
let's say if we disagree with you, what was the tribal issue of fact that you raised?
The tribal issue of fact is that he has not satisfied his burden of proof. He has to come forward with evidence in admissible form.
Let's assume that he did. So let's say, what did you put in to say issue of fact?
Assuming he did?
Yes.
Assuming he did, I wouldn't. I wouldn't have anything else.
Let me ask you this question.
Yes.
So, because it just seems to me that this is a lot like Walensky. Why isn't this like Walensky here?
Why is it not like Walensky?
Yes.
I'm not saying that it's not like Walensky.
Oh.
All I'm saying is that he hasn't satisfied his burden of proof. On a summary judgment motion, he has a certain standard. He's got to come forward with evidence from a person with personal knowledge of the facts. He has not satisfied that.
But that would mean that no unwitnessed accident could ever make, a plaintiff could never make out a prima facie case on an unwitnessed accident.
At trial or on motion?
No, on motion. And we've held many times that the plaintiff can. You're arguing unless somebody actually saw it happen, other than the plaintiff testifying about what happened to him, you could never make out your prima facie case. That's not it might be the second department that might be the rule, but it's not in the first, and you know it.
Judge,
So,
all I'm saying is, and I will just close with this if I can. I believe that the motion court judge got it correct because I believe that he has to come forward with evidence in
that's
admissible
not
form.
our rule here in the first department. Again, it might be in the rule in the second department, but it's not in the first.
I understand. If there are no further questions,
All right, thank
thank you.
Give me a second, thank you.
Absolutely, Your Honor.
Nope. Go ahead.
Okay, thank you, Your Honor. As Your Honor's noted, counsel misstated the law. The plaintiff does not have to see the object fall. There are many cases, Milan, Harasny, Justice Scarpula was in a recent one. You all covered one or the others, Torres Quito. There's a whole bunch where the plaintiff did not see the object fall. In this case, there's even much stronger grounds. Putting aside that counsel is wrong, the accident reports, which they waived any inadmissibility since they relied on it and authenticated it, clearly said that it was unsecured. But in this case, unlike Harasny, Milan, and the others, plaintiffs saw the object that was being used at the time that ultimately fell on him and struck him, this 10-foot, 600-pound, or at least over 200-pound object where, by all accounts, it's uncontroverted, it fell and struck him, and then the ambulance came. There's nothing else to say unless Your Honors have any other questions. Thank you.
Thank you. No. Rodriguez versus RXR Glen Isle Partners. Oh, I'm sorry, that is submitted. People versus Jason Pagaro, that's the next case. No, yes, that's the next case. Okay, you may begin. Thank you.
Good afternoon. May it please the court. Matthew Bova for Mr. Pagaro. The unconstitutional proper cause standard that the Supreme Court invalidated in Bruin tainted the indictment in this case, requiring its dismissal. Now, Mr. Pagaro was subject to the unconstitutional proper cause standard at the time that he was arrested for violating the state law governing unlicensed possession of a firearm. The Supreme Court struck that down. Therefore, it taints the indictment because there's no other lawful basis to have denied him a license. Below, the prosecution...
Can we agree that the Supreme Court did not strike down the whole
Of course.
licensing? Okay.
And I think that...
So no, the Supreme Court didn't strike down New York's entire license.
course.
So your client is subject to everything else under that licensing statute except the one provision that was struck down, right?
Well, in general, yes. I mean, the Supreme
Okay.
Court didn't say one way or the other whether the remaining
Well, we
But-
assume, but the New York Court of Appeals has said it, right?
Well, the Court of Appeals hasn't reached that question either, but I think the question presented here is, on this record, where you have the unconstitutional proper cause requirement and no other lawful basis.
Go back, because what you're saying is that this 7th month delay, right, in securing a license, that violated your client's constitutional rights?
Well, that's part of it, yes, Your Honor.
Okay, so let's stick with that. Because I think we all agree, you know, in light of, People v. Johnson, it's clear that, facial constitutional challenges do not need to be preserved. But, so how is this length of delay, how is that a facial challenge as opposed to not being an applied challenge?
Well, that may not be a facial challenge.
So it's not, it's applied.
The delay is as applied, but what is
Okay,
facial?
so I want to stick with that. So, would you agree that that we have to talk about the waiver of appeal as it relates to the as-applied challenge?
No, because the logic of Johnson applies equally to facial constitutional defects and as applied. That is an impossible line to draw, and I think if this court tries to draw that line in the context of waivers, there will be textbooks written in the next 20 years from the jurisprudence coming out of that. But I think, putting that aside, Your Honor, as to proper cause.
One second, I just want to make sure that you are saying that one cannot waive an as-applied constitutional challenge?
Yes, Your Honor, because
Have you ever seen a waiver of a 5th, 4th, 6th, 8th, 14th Amendment as-applied challenge?
just to be clear, as applied as to the substantive constitutionally protected conduct.
Yes.
Yes, no, as
You
to
don't
that.
think, aren't there legions of cases where we've upheld, and not just us, but courts across the country and federal courts and state courts have upheld as applied waivers?
Well, my point is simply that Johnson says that appellate review is critical in the context of making sure that when someone is engaged in constitutionally protected conduct, that they get relief. But even if this court disagrees with that as applied point, the proper cause standard is facially unconstitutional.
Okay, well, but I want to stick with this as applied, because let's talk about this waiver. So is it your, contention that the waiver of appeal is invalid? And if so, what makes it invalid?
It's invalid because this is a constitutional challenge arguing that Mr. Peguero had a constitutional right to engage in the conduct.
No, I
that he was
understand.
engaged in.
I'm talking about the waiver of appeal. Is it your contention that the waiver of appeal is invalid? That's where I'm going.
It's invalid under Johnson because you cannot waive an as-applied challenge when it comes to substantive conduct under the logic of the Johnson opinion. But I understand that might be a harder argument.
It is.
I want to go to our facial argument, which I think is much.
I want to go to where I am. So I want you, we're not getting there yet. What is it about the waiver of appeal that's invalid?
We're not contending for the purpose of this argument that there's something specific about the waiver itself.
Okay.
It's simply that under the logic of
You're just
Johnson.
saying that despite the waiver, it doesn't have to, it's preserved. The waiver doesn't,
Yes, Your Honor, yes.
doesn't undercut that, okay. So now, in terms of, you want to get to the cause part,
Yes, Your
right?
Honor.
That wasn't the reason he was denied, right?
So the reason he was denied was, that's what's so interesting about this record is we actually have a record about taint because the proper cause standard is invalid. Then we have a denial after the fact, after the arrest.
Yeah,
And
but
the
you-
only
but the-
basis for the denial, Your Honor,
It's a pretty lengthy one, right? 5 criminal court summonses, 3 complaints, 5 domestic violence reports, and 6 moving violations.
yeah, so at this time, Your Honor, the proper cause standard has been invalidated by the time they reach this, so they can't rely on that. So the only thing they rely on are arrests, accusations. Now, Rahimi is a really good example of this. Rahimi upheld a statute that said when there is a judicial finding that someone is an active threat to an individual in the context of an order of protection, you can disarm. There is no historical tradition, and I don't even take the government to really be pressing this here, that you can disarm someone because of allegations and arrests. I mean, in the context of the First Amendment, for example, that would be truly radical. The suggestion that you could permanently disarm an individual because I pick up the phone and I say that my neighbor is engaged in violent conduct, they get arrested, boom, they're disarmed. There's no tradition for that. And also, if we look at the...
So I don't understand how this is not an as-applied challenge because it's specific to your client's factors. This is a classic as-applied challenge.
And this will be the last questions, and then anything else on rebuttal?
Yes, Your Honor. So there's a facial challenge as to the proper cause standard. When it comes to remedy, when it comes to whether Mr. Peguero is entitled to a remedy, we agree you have to look at the facts. But that doesn't change the fact that we are challenging the facial constitutionality of the proper cause provision and arguing that it harmed Mr. Peguero and thus tainted the indictment because there's no other lawful basis to deny him a license.
Thank you.
Thank you.
Maria Wager for respondent. Good afternoon.
Good afternoon.
To the extent defendant is making a facial challenge, this court can easily dispense with that claim on the merits because Johnson, the recent Court of Appeals decision, defendant here cannot show that it would be unconstitutional in every application. He didn't even argue that, much less show that. But it's respondent's position. That
I'm
this
just
is-
curious, so do you think that Johnson says that you can't waive an as-applied challenge?
I disagree with my adversary's position.
I think it was just Johnson made it really clear because we've upheld waivers of as-applied challenges to many constitutional rights, right?
Yes, correct, Your
Including
Honor.
in this circumstance.
Sorry, Your Honor?
Including in this circumstance.
Yes, including the circumstance. And in fact, the Court of Appeals took pains to make that distinction. And they gave the reasoning behind it because a facial challenge transcends the individual interests of a defendant. Here, this is all, his entire appeal is about his individual interests, this specific proceeding with him, his application, the delay in processing his application, his personal eligibility. Now,
So assuming that his appeal, if counsel doesn't argue this, so assuming that his appeal waiver is good, which counsel doesn't dispute, then your position is he's waived this,
yes.
correct?
Yes. He's waived, and also he has to show standing. So the Johnson Court, it was waiver and standing, should apply it an as-applied challenge.
Well, I think here he applied, right?
Well-
Maybe that might be enough. Who knows?
Okay, I respectfully disagree. I think you have to submit to the process in full. And that brings me to another fatal flaw in this appeal is we do not have a robust record at all. I disagree with that. Defendant's claim rests on an assumption, and he starts the reply brief off with this, that the government sat on his application. It was actually 6 months and 12 days later from when he submitted the application to his arrest. So he went 12 days, we're past the application.
I was curious, I didn't see any cases. Are there any cases where anyone brought an Article 78 proceeding or something? Well, obviously he had that relief and he didn't seek it, right? He could have brought an Article 78 and say, you're taking too long, either deny it or it'll be deemed denied, right? He didn't do that.
That is the remedy, Your
Are there
Honor.
any cases that give an outer time limit of how long it should take, Article 78 cases for a gun license?
I didn't see an outside limit, but there's also within the penal law statute, that 6 months can be extended for good cause. And we don't know whether that happened here or not because we have an incomplete record.
Right.
But also, we don't even know the cause of delay. Now, when the licensing, when they denied his license after this arrest, 3 weeks after this arrest, it was denied in part because defendant gave incomplete information and made false statements. So defendant himself may have been the reason for the delay in doing the background check. We're missing that from the record because interestingly, in his motion below, defendant attached his Florida permit license, not his New York license application. So that application is not even part of this record. So when defendant says that but for the proper cause, he would have gotten a license, we do not know that.
We don't
know
have,
what he
and we don't really have a record to show that. I mean, he made the allegation, I understand, he argued that, but we don't really know why.
Exactly, Your Honor. And all this about his criminal record, we don't know what the board would have done because he didn't wait for that decision. So in addition to everything they said, this arrest played into that denial because here he has an application pending and he arms himself with a loaded gun. And there is no authority that legalizes unlicensed possession. So that played into the denial also. But he wasn't prosecuted at that point. He wasn't arrested at that point. The denial came 3 weeks after his arrest here. There's no further questions. We rely on our brief.
Thank you.
The duration issue aside, the proper cause standard is facially unconstitutional. And what I think the government's position is that as long as you have to look at something other than the statute, that makes it somehow as applied. That's just not what the definition of as applied is. You have a facial defect, then we have to determine in the court system what remedy the individual is entitled to. That is always going to be a fact-intensive question, but that doesn't change the reality that the party is challenging the facial constitutionality of a statute. As an example, if a statute says that members of a particular creed or race cannot get a gun, you're also, if that person's prosecuted.
What is it, what do you think is your facial, please explain to me what you think your facial challenge is, that the proper cause requirement.
Is unconstitutional in all applications.
In all applications. And how does Johnson affect that?
Well, Johnson addressed a much broader argument. Johnson addressed a severability argument, effectively a poison pill.
No, not just that. It absolutely addressed proper cause.
Oh, well, yes, but the argument there was not the argument we're raising here. The argument there was the proper cause provision effectively torpedoes the whole statute. So even someone that's 15 years old has a defense because it kills the youth requirement, it kills all the prior felony requirement. That's not our argument. Our argument is based on causal connection. We have a facially unconstitutional proper cause provision. The only basis for otherwise disarming Mr. Peguero from the record is he has been accused of offenses and he has been arrested. That is not a valid basis for disarmament. Thank you.
Acevedo versus City of New York. Good afternoon.
Good afternoon, Your Honors. May it please the Court, I'm Joseph DePaula. I represent the plaintiff appellant, Ruth Acevedo. The court below erred for two reasons. First, it was error to disregard the opinion of plaintiff's expert engineer as to the cause of this roadway defect simply because he didn't conduct an in-person inspection.
Well, the photos, right? He also looked at photos.
Yes, Your Honor.
So now, do we have any evidence about who took the photos, when they took the photos? Did they, fairly and accurately depict the accident location?
We do have the photos properly authenticated by the plaintiff at her 50H hearing and then again at her deposition. And she talks about the photos in the record on appeal.
Isn't part of the problem, because I looked at the photos also, and I know the plaintiff said that this was what it looked like at the time, but didn't you, how can you show that the crack on the roadway, whatever you want to call it, but let's say the crack on the roadway was actually immediately visible after the location was last repaired by the city? Because there's testimony, the city put on a lot of witnesses that talked about the repairs that they made. They filled 5 holes this day and 9 holes that day. But your position, at least part of your position and your argument, is that the crack was immediately visible even after they finished their work. So how can the expert say that if he never went to see it immediately afterwards or ever actually?
Very simply, Your Honor, it's 2 different materials in this area. There's a concrete bus pad and then it's a joint with the asphalt roadway surface. And that area, that joint was degrading, it was creating a hole. The city at some point presumably had a defect, number
Counsel, I think you
9003.
just answered the question in that what you're saying it was degrading, creating a hole, implies a process that happens over time.
No, I didn't. I apologize, Your Honor. I didn't finish. When they went out and they patched it, they put asphalt on top of concrete.
But we agree, counsel, here that the city worked in that location 58 days before this accident.
It was approximately, 2 to 3 months. They did work in February.
So from that time period, what evidence is there that whatever work they did, they immediately left, or it was apparent that they left this gaping crack, whatever it is, hole, that was a result of their work?
2 things, Your Honor. You're actually putting one material on top of another. There's a height differential right there when you're piling asphalt on top of concrete. 2, the city had to go out there twice for the same defect. They went out there on February 26, 2019, and then they went out there again on March 4th, 2019. Why is that? It's because the defect, the repair of it was immediately apparent. They had to go back out and fix it again.
Who said that? Who said that? Other than your expert who has no personal knowledge.
My expert, Your Honor.
Your expert has no personal knowledge, didn't go there, didn't see anything, says, based on this photo, which the plaintiff testified looked at the time of her accident, but could have been completely different 2 months before, because we don't know. That's all you've got, right?
Yes, my expert's opinion on that point, Your Honor.
Okay.
Now, I just want to go back. So what was the basis of the knowledge? Because I think, what your expert said, that the city, used incompatible materials. I mean, what is the basis of that knowledge?
His visual observation of the different materials in the photograph, Your
Let
Honor.
me ask you another question. How did your expert establish that the city's work immediately resulted in a dangerous condition?
Based on his visual inspection of the photograph, Your Honor, he's looking at two different materials piled on top of each other in a crack. And that's the basis of his opinion. It, candidly, should be common sense. You really shouldn't need an engineer to say that when you put asphalt on top of concrete inside of a hole, it's really not going to work.
Over time, it may not work, but does that mean that there's a hole that's immediately apparent after they do it?
It's an immediately apparent height differential. You can't make the asphalt level with the concrete bus pad because you're piling one material on top of another, and that's what the photograph shows.
So it's an immediately apparent height differential because they use incompatible substances to fill it.
Yes, Your Honor.
Does your expert say what that height differential is?
No, he doesn't measure it. He's never out there. It's based on my client's testimony, having authenticated the photographs which show it. And that type of analysis is routinely done by experts looking at, for example, car crash cases and what a dent looks like. They don't inspect it, but they estimate based on the photograph. The second reason, Your Honors, that the court below erred is the city failed to meet its prima facie burden here. There are two records from a special event inspection, a Tour de Bronx bicycle riding event. And in 2017 and 2018, this block where this happened, East Tremont, at or near 177th, it's only 500 feet long, that area.
What I'm going to let you do is you can pick up on that during rebuttal, okay?
Thank you, Your Honor.
Your Honors, may it please the court, my name is Amanda Abata and I represent the respondents. I just want to begin with regards to the cause and create aspect of this case. I want to sort of draw the court's attention that in addition to not going there to the site to do an on-site inspection, the real issue with the expert Belize's conclusion is he said that DOT's alleged defective repair caused a height differential that resulted in the plaintiff's injury. But we have plaintiff's own testimony and the pictures that she marked up that said that she stepped off the bus into a crack, a depression.
Hole, right?
A
Now,
hole.
it doesn't matter. It's not that there was a lump, there was a hole.
Exactly.
That's what she says.
Exactly. And that's what caused her to twist her ankles, resulting in her injuries. And that is easily and markedly distinguishable from the defect that Belize said the city immediately created, which he described as, quote, a raised bulging mound of asphalt. So that is markedly different with regards to the defect that he says the city created, of which obviously has no evidence, and what the plaintiff said caused her injury. And I want
to— Can you address the special event inspection reports? And then I think it was also Cotlin's deposition where he was questioned about these reports and he said that the repairs were not performed. Can you address that?
Yes, Your Honor, very quickly. So with regards to Codlin's testimony, plaintiff mischaracterized it. Codlin was questioned on the inspection reports and he was asked whether the conditions listed there, mainly that there were potholes on two specific segments of Tremont Road. He was asked whether the wear and tear and the potholes there were repaired. He answered that the reports do not list a repair date, but that any subsequent repairs would be detailed in the maintenance and repair records. The city then presented maintenance and repair records that show that the city repaired potholes in the vicinity of that accident site on East Tremont between 177 and West Farms prior to plaintiff's injury. So like I said, DOT showed evidence that the potholes identified in that inspection reports were repaired at least 2 months before plaintiff claimed that she was injured. And we know that because we have Messina, who's the director of the Road Wear Repair Division. He described the process by which the city patches its potholes, which is essentially that they get a single complaint of a pothole on a road. They dispatch a crew. When the crew arrives, there's a supervisor who walks the length of the road from crosswalk to crosswalk. In addition to the pothole that's complained of, they identify other defects on the road and they repair all of the defects. And with regards to outside of those reports, there's also a complaint that plaintiff tries to use to establish prior written notice, which is a complaint of a pothole adjacent to 1074 Tremont Avenue near West Farms. We have here repair records that show that a repair crew was dispatched in February February of 2019 when the complaint was received. The crew on that specific day patched 5 holes because, again, in accordance with their practice, that they don't just patch the specific complaint of pothole, they patch other potholes, and maybe they saw more than they could repair that day, because we also know that in early March, a second crew went back to the same location based on the same complaint to patch 9 additional potholes. So we maintain that those records show that at least, again, 2 months before plaintiff's injury at this alleged site, we have that the city repaired all the repaired potholes in that site. And once a reported defect has been repaired, the city must receive notice that the roadway is again in need of repair in order to satisfy the prior written notice requirement. And then there are no other questions, Your Honor. I ask that you.
All right, thank you.
With respect to the testimony of Mr. Codling and the repairs, I took his deposition. I asked him after, what does it mean when this record, special event record, says not been repaired? And he says, obviously, it means it's not been repaired. Then I asked him, in this whole discovery response from the city, this preliminary conference order response, do we have any records here that show that these defects have been repaired? And he said no. He explained that if there were a record that was tied to those defects, the record would say it was responding to a special event inspection report. So the city fails here. It cannot show that it repaired those defects. With respect to Mr. Messina's affidavit, all he talks about—
Were those the defects that your client alleges she fell on? You say they can't show that they fixed all those defects. Does that include this defect that she alleges she fell on?
Yes, Your Honor. With respect to Mr. Messina, all he talks about is practice and procedure. He says, yeah, it's our procedure. We go out there, we fix everything we see. He never says we fix these potholes that we got reasonable notice of in the Tour de Bronx inspection records from 2017 and again in 2018.
Well, how could he say that unless he actually did it himself? He has no personal knowledge. He has no, how could he say, yes, I can tell you that I was on the crew? That would be the only person who could say that.
And
that is true of every case against the city. The city has to rely on its records because it's a big city and a lot of repairs are going on. So you're asking him to say personally, yes, I personally know that that was it?
in the absence of a record that connects the repair
He
to the
said,
defect,
this record shows that we repaired.
there has to be something else there, Your Honor. The city has a system for this. They record a defect, they give it a defect number, and then when the pothole crew goes out, they write that defect number on the repair. That's how they establish this through records. They don't do that with the Tour de Bronx records here. There is no repair record connected to those defects that have been reported. If there's nothing else, Your Honors, I'd refer to my briefs and request that the court reverse the order below.
Thank you very much.
Thank you.
T, Hayden, matter of Hayden T. Ready?
Your Honor, before I begin, I had asked for 8-2, and Your Honor, I heard said 5-2.
I did.
You're asking, if I may have additional time and forego the rebuttal, I would appreciate that if Your Honor is looking for me to spend less time at the podium.
All right, I'll give you 6.
Thank you, Your Honor, I appreciate that. So, Your Honor, may it please the court, Philip Katz, representing the appellant mother, Mariceli T. We're asking this court to intervene now in the middle of a trial because the family court has stripped my client of her fundamental right to a vigorous defense in a termination of parental rights proceeding. By allowing the agency to call my client, who is a hostile witness to their case, then prohibiting me, her counsel, from using leading question on cross, the trial court has basically allowed the agency to wield the sword of the state to curate a narrative that is misleading, while denying my client the ability, and she's the mother fighting for the right to rear her child without government interference, the shield of cross-examination to do that. We ask the court to grant leave to appeal and to reverse the ruling for two reasons. First, as our chief judge indicated in the matter of Joshua J., to wait for a final ruling here would render any future remedy illusory. Second, the trial court relied on a logical fallacy, created what I'll call an inverse rule. It erroneously assumed that the authority to expand the petitioner's privileges somehow granted that court the power to restrict the respondent's rights.
Don't we generally only allow people to cross if the witness is anticipated to be hostile or evasive or biased? And how would we have expected that for her to be that way when her own counsel, you or whoever from your office, was representing her?
So I'm not sure if I understand that question, Your Honor, because in this particular case, it was the agency that called my client. Right?
Yes, and then you followed up with your questioning.
Correct.
But that's not considered cross-examination. I mean, you're asking even if it is, I mean, it's your client. So why would you be permitted to ask leading questions to your own client under any circumstances?
So that is, again, where I think this is this inverse rule. Your Honor, I know Your Honor is asking that question. You could ask, I've talked to a lot of attorneys about it. I've talked to other people about it. There is a statutory and constitutional right for my client to have a full-throated defense. And
I don't understand, but so yes, but that's not what you're talking about. You're talking about I should be able to ask leading questions to my own client.
Yes.
So let's start with what is the purpose of allowing leading questions? It's an evidentiary issue. It's not a constitutional issue.
Respectfully, it is a constitutional issue.
No, okay, let's say we disagree.
Okay, we certainly disagree.
Let's say it's an evidentiary issue. You can put your client on and ask her a million questions. She's got the full and fair opportunity to put on her case. You have a case to put on in chief, you can put her on. Your objection is to not being able to ask her leading questions. So, again, let me ask you, what is the purpose of allowing a lawyer to ask a witness a leading question as opposed to an open-ended question?
The purpose of doing that is to permit the individual to surgically rehabilitate a client.
No, it's because we assume that the witness is hostile and that they are not going to, and that is why. Okay. Well,
Counsel, let me
Richardson.
Let me ask this. So when the agency called your client as his witness,
yes,
counsel did not object, right?
They have every right to call my client as a witness.
Okay, so the answer is yes. So the answer was no.
I did not object.
And certainly, did you raise? Well, I don't know if it was you or another attorney.
Was me.
Okay. Raise any objection during the direct examination?
I would not have, and there was no reason for me to do that.
So now my next question. So when you are questioning your client, in any way, did your client act evasive or hostile towards you?
So, Your Honor, that's, again, having been there, I could tell you what happened, and that's not how it happened. So basically, my client was called on the first day of the hearing.
Right.
And I say it was ambushed because there was no notice of it. Directly examined by the
agency. She's a
agency.
party, right?
What was that?
She's a party.
She's a party, but
so
I'm going to go back and ask my question. So the question is, at any time, did your client at any time, because you're questioning, did she act hostile towards you?
So we didn't get to that point, Your Honor, because what happened was, at the end of questioning, I started to question. It's a cross-examination. And again, obviously I understand some of this bench doesn't think that a cross-examination necessarily should permit leading questions. I am here because I disagree.
Okay.
So at that point, there was an objection by the agency to me leading my client. That was briefed by the parties. The judge issued a decision. Based on that decision, we are appealing this now. My client has not been on the stand yet.
Did the court say you couldn't ask her questions?
Yeah.
No,
Did the court say you couldn't ask her open-ended questions to rehabilitate your client?
no.
Only thing the court says is you may not lead that witness, correct?
That's correct.
That was the only restriction on your right to cross-examine your witness, right?
That is correct.
Okay, and you're saying that that is a constitutional violation?
And a statutory violation, Your Honor, because the rules of evidence are clear. A court does not, I'll point this court to the rules of evidence 606 sub C. It does not, it says in there very clearly that the court shall permit leading
What
questions.
rule of evidence?
606.
In what statute?
This is in the New York Evidence Guide, section 606.
Okay, that's not a statute, right? We don't have a statute for evidence.
This is the last question.
Yes,
Now, certainly, you were free to call the mother on your own case and put on your own case, right?
Of course.
Okay, thank you.
Good afternoon, may it please the court. My name is Jeffrey Blankoff, and I represent, I should clarify, the agency which is Graham Wyndham. Sheltering Arms was the precursor agency which closed, and we have taken over. In essence, I would essentially be relying on my brief, but I do just want to clarify one point, which is when counsel mentions that he felt ambushed, I would disagree with that. September 4th of 24, when the case was to start, I put on the record that I intended to call the respondent. The respondent did not, in fact, take the stand until February of 2025. So I do just want to make that clear.
Oh, so it's your
They had
position. that
several
they had
months' notice
Yes.
that she would be your first witness.
Yes, and I also do want to clarify that in terms of the progression of the case, I want to go to Your Honor's question about could there have been questioning. There certainly could have been. There was a choice made not to cross-examine.
So it's just the question of leading, whether one could lead or not whether or not she had the full opportunity to rehabilitate herself on cross.
Absolutely.
Right? Counsel could have asked her whatever open-ended questions he or she wanted to rehabilitate herself.
Yes.
It was just whether one could sort of put words in her mouth and ask her to say yes or no.
Absolutely.
Okay,
And I
and
do
that's the only thing that's on this appeal, correct?
Absolutely, and just one point, which is that this appeal, I had argued, should not have been brought at this time because the order that exists is not dispositional in nature, but going to the merits of it. I also want to point out, while 606 is not a statute, that there is a footnote to that guide, which I cite in my brief, and which makes clear that in a civil proceeding, when one party on its direct case calls an adverse party, the court may preclude the attorney for that party witness from asking leading questions on the cross-exam. That's in the footnote. And I do just want to clarify one thing, and with my apologies, I noticed as I was sitting here a formatting mistake in my brief. I apologize for that. It's on page 11. The last sentence in what is a quotation actually should have been in the next paragraph. But unless there are other questions, I would otherwise rely on my arguments.
Thank you very much. Thank you both. People v. Silva.
Good afternoon, Your Honors. Elizabeth Batkin from the Legal Aid Society for Rafael Silva. The gunman in this case asked Mr. Silva a question: should I pop him? By responding, yeah, pop him, Mr. Silva may have encouraged the shooting, but that did not make him an accomplice to it under the law. I think it's helpful to start with the Second Department's decision in People v. Fonerin. In that case, the court found that it wasn't enough where the defendant said, and I quote, "Do that shit, man," to his co-defendant, who then lit the victim on fire. And what Fonerin establishes is that words of encouragement, however odious they may be, are simply not enough to make someone an accomplice. It also shows that words that may sound like a command in one context, like, quote, "Do that shit," or here, yeah, pop him.
You know, the Second Department case is totally an opposite. Why is it? Because in that case, the defendant said, don't do it, and I'm paraphrasing, I'm not gonna use profanity, don't do it, and also, took video, but then paused and rendered aid to the victim, and we do not have that here at all.
I think the cases are quite similar in the sense that in both cases, it's the other party, it's the principal actor who introduces the idea of the crime and then completes the crime after the defendant says words of encouragement. And in People versus Fonerin, it was only after the
I think,
defendant.
counsel, you're leaving out a lot of facts here, right? A lot of surrounding facts, and those facts include the fact that the victim who was shot and the defendant were at some point when they used best friends, that fell apart. They had a recent argument, right? And there was acrimony between them. So now the defendant finds the complaining witness or encounters with the complaining witness in the street. It's the defendant who brought the shooter with him, right? It's the shooter who asked the defendant after the victim gets into an argument with defendant, should I pop him, right? Defendant says, yeah, pop him. Takes out a gun, shoots the victim. And then what does your client do afterwards? He gets in the car and leaves with the shooter.
We watched the video.
Yeah, we saw the video, and it seemed that this went over a long period of time. This wasn't a 10-minute video. It went on for a long time. And aren't we, under our case law, asked to look at like the entire circumstances and to figure out what the intent may be? But he left with him, and he was hanging around with him for an hour, 2 hours. It was in the middle of the day, and then it seemed to get darker. So, I mean, things were moving along. This was it wasn't just a 1 minute, let's pop him, yeah, let's do that.
So the prosecution's theory is that the context of this beef that the two of them have supplies enough information for us to interpret Mr. Silva's words as a command. But that's just not true. First of all, the idea that Mr. Silva ordered his friend to be shot over his girlfriend's missing empty wallet just isn't a reasonable inference to draw from the evidence. And
But that's different from whether there's sufficient evidence. You're saying that the jury didn't, the weight of the evidence wasn't enough, right?
we're arguing both. So I don't think we have.
All of the circumstances that my colleague you're saying all of that in and of itself doesn't have enough weight of the evidence to.
I think all of that context.
Or not legally sufficient, rather. Let me start. So that you're saying all of that evidence, all those circumstances wouldn't be, if the jury found that all to be true, legally sufficient?
Yes, I don't think it is sufficient for
You're
us to.
saying that it's not legally sufficient for the two people to have a beef, to meet in the street, to have a fight in the street, and the guy turned to his friend, and the friend says, pop him, and he says, yes, pop him, and the guy pops him, and
Yes.
they get in a car. You're saying all of that together
Because
is
we do-
not legally sufficient?
We do not know anything about who the shooter was. We don't know what his
What does that matter? We know he shot the victim.
We know that he drove the car. He had the gun. He drove the car there and away after
We
shooting.
know that we could reasonably infer that the defendant knew the shooter, right? Because he came with him and left with him, right? The shooter asked him a question. This is not the shooter's problem, right? This is not the shooter's beef, to use street language. This is the defendant and the victim's problem. The shooter intervenes and then asks, what do you want me to do in essence? What do you want me to shoot him? And he says, yes, shoot him. Why isn't it not right that the jury made that conclusion?
Well, first of all, even if it was legally sufficient, there was at least a reasonable doubt that this was nothing more than mere encouragement, that the shooter was looking for encouragement or validation and not for permission or an order.
Based on what? The shooter said nothing to the defendant at all before this, right?
We don't know.
We're looking at the video, and
the shooter is engaging with.
Did anyone testify that the shooter said anything to the defendant, or that the shooter and the defendant had any relationship?
The shooter and the defendant?
I'm sorry, the shooter and the victim, right?
In fact, yes. The defense counsel put on a witness, a police officer who drove Mr. Nieves to the ambulance. And in the ambulance, what Mr. Nieves told that police officer was that the shooting happened after the shooter said to him, "What are you looking at?" And then he shot him, which suggests that there was potentially more going on then met the eye that maybe there was beef between the shooter and Nieves. The problem is that we just do not have enough evidence to interpret these words as a command rather than encouragement. And it's not that these words would never be enough to make someone an accomplice, but on the record in this
Well, you're right. I can imagine an instance where it's not enough, where he says, should I pop him? You say yes, and then he shoots him. He's like, oh my God, you really shot him. Or you call the police, or you leave. Instead, he gets in the car and leaves with him.
The fact that he gets in the car does not make him an accomplice, and I think the fact that he may, first of all, he does seem surprised by the shot. He flinches and he backs.
Yeah, because he doesn't want to get shot. Presumably, right? When somebody pulls a trigger, that's a startling event.
Yes, but I think the problem is that there are a lot of things we're missing. I think your honors are focusing on what we have, but what we don't have is we have no information about who the shooter was. We have no information about the relationship between the shooter and Mr. Silva, who had power over whom, who was leading who might have been scared of whom here. The shooter is the one who drives. The shooter is the one with the gun. There's sufficient evidence to draw an inference, at least a reasonable inference, that the shooter had the power here and that Mr. Silva was merely encouraging him.
Thank you, counsel.
Thank you, Your Honor.
Good afternoon, Your Honors. Jamie Maston for the people. There's a lot to push back on here.
Well, let me just ask you, was it reasonable for the jury to find that it was the defendant and the victim who had the disagreement, that it was the defendant who was looking to hurt the victim? Was that an unreasonable inference based on the evidence that was adduced at trial?
Not at all, and not only was it a permissible inference, but the fact that the beef occurred between the defendant and the victim was almost conclusively proven by independent, unassailable evidence. The jurors saw text messages.
Text message, right.
Exactly, about
I want the wallet. I don't.
I'm sorry, I don't mean to step on
No,
your
yeah, I'm interrupting you. I'm sorry.
No problem. And so not only did they see text messages at the start of this so-called beef, but they also literally saw the wallet in Nieves's hand when he returned it the next morning. So all facets of this story were corroborated by evidence that the jurors could see and evaluate.
I take it that you would agree that in isolation, the term, should I pop him, that alone could be open to many interpretations.
Sure.
Right? But here we have more than that.
Absolutely. And the verdict here did not just rest on the defendant's 3 words. It rested on the entire series of events because his 3 words do not exist in a vacuum. They exist in
How do you respond to your adversary's position that we don't know what the relationship was between the victim and the shooter, in that she alleges that part of the record was that the shooter tells the victim, what are you looking at?
So that comment about what are you looking at was fully aired before the jury, and it basically boils down to a credibility contest, which the jury reasonably resolved in the people's favor. There's no reason for this court to second-guess that jury's decision there. As to the relationship between the defendant and the shooter, I think that the conversation was conclusively proven by the 2 witnesses who had heard the shooter turn to defendant. The record is very clear. It's stated multiple times. The shooter turns to defendant to specifically ask defendant, should I pop him? And defendant turns back and answers without confusion, without reluctance, without pause, and says, yeah, pop him.
Well, let me stop you here. How do you, because I think it plays into my next question, which is your adversary saying that we don't know who had the power here. I would say the shooter did because he's the one with the gun, right? So how do we know that the defendant was not under the control of the shooter? Was that developed by the defense?
I don't think it was a necessary element that we had to prove for acting in complicity for these 3 charges.
But it goes to intent, right? If they somehow show that the defendant was scared to death of the shooter, doesn't that play into it?
There is nothing in this video and nothing in defendant's behavior that would go towards this.
Is there any evidence in the record that the jury could have drawn that conclusion from?
Absolutely. As soon as the gun was pulled out, defendant did not try to push that gun away from it being pointed at Nieves. After the shots rang out, you can see he sort of touches his ear, probably because the shots are loud, but he doesn't run away. He could have.
Absolutely not. There's nothing in the evidence, there's no evidence submitted that would lead the jury to conclude that it was the shooter who was running this whole thing and not not the defendant.
No, the defendant literally called the shots that led to the shooting of his friend. There was a valid line of reasoning and permissible inferences that could lead this jury to believe that the reason this gun was displayed, aimed, and fired was because of the defendant. And I think it's really telling looking at the defendant's behavior after the shots rang out, because he could have run in the opposite direction as the shooter. He didn't. He could have run home. He didn't. He turns the corner and he didn't render aid
to his former friend.
Exactly. He instead runs straight to the shooter's car and voluntarily jumps into that gunman's vehicle. And that spoke volumes.
And it's not only the defendant's girlfriend runs into the car as well, correct?
Defendant's girlfriend runs into the car. That's true. But we don't know where she lived. Unlike the defendant's address, which made it into the record. He lived across the street from the shooting. He could have just run home. He didn't. He ran straight into the shooter's car, and that told the jury that defendant was saying, wherever the gunman goes, I want to go too.
Or at least that's a reasonable inference.
It's a reasonable inference, and it perfectly aligns with someone whose intent was to have Nieves not just punched, but shot. The remaining arguments in this case, again, boil down to a credibility contest that the jury resolved in favor of the people, and it's no wonder why. Nearly every facet of Nieves's and De Jesus' testimony was fully corroborated by evidence that, again, the jury could see with their own eyes. They didn't have to take the witness's word that the defendant ran it straight to the shooter's car. They literally saw it. There's no reason to disturb the verdict here. Unless there are any questions about summation or excessive sentence, we would rest on our brief.
Thank you
so much.
I'll rely on my opening and my briefs for the sufficiency, which I think we've argued enough about. But we are also asking this court to reverse his conviction on the basis of the weight of the evidence. There was at least a reasonable doubt about the prosecution's theory here that Mr. Silva, merely by answering this unidentified gunman's question, was commanding his friend to be shot on the basis of a missing empty wallet. There's reasonable doubt, and the jury was unjustified in finding that there was not reasonable doubt. So we are asking for that. And I'd like to briefly touch on the prosecutor's statements in summation, because they did mislead the jury on the exact issue of sufficiency and should give us some pause in deferring to the jury's verdict. So specifically, the prosecutor told the jury twice that the only way to find Mr. Silva not guilty was if the prosecutor's witnesses were mistaken or lying about whether he had said the words, "Yeah, pop him." But as I spent 5 minutes arguing earlier, that's completely untrue. Even if Mr. Silva did say, "Yeah, pop him," the jury was still entitled to find that it wasn't enough to make him an accomplice to the crime. And actually, as our conversation has revealed, this is actually a very complicated and perhaps unintuitive question, this issue of when words are sufficient to make someone an accomplice. And yet the prosecutor essentially took that question away from the jury by suggesting that the only question in this case was about credibility and not about sufficiency. So either by finding that the prosecutor committed misconduct in summation, or because Mr. Silva's convictions.
To the extent that the whatever was said by the prosecutor was not fair comment on defense counsel's statements in summation, putting that aside, wasn't any error that may have been caused by the prosecutor's statement cured by the court's instructions?
I don't think so, because the court never corrected those misstatements when they were said, and so the
Was there an objection when they were made?
There were objections to both of them, yes, Your Honors.
Thank you.
Thank you very much.
Masumi versus Ganju. I hope I'm pronouncing that correctly. If not, you'll correct me. Thank you.
Sorry there, Your Honor. That's not my pen, so I'm not sure what to do with it, but thank you, Chris. John Williams from Williams and Connolly for Plaintiff Cyrus Masumi. Your Honor, you did correctly pronounce both parties' names as I understand it, so thank you.
Thank you.
Your Honors, this is a fraud case. It is before the court on the trial part's grant of summary judgment to defendants, with the court having found that no misrepresentations were made as a matter of law. That conclusion was error, and profoundly so. Defendants made 3 misrepresentations that each individually and collectively amount to fraud. To be clear, however, our burden today is not to convince you that these statements were false or that their conduct was deceptive, although they were. It is rather defendant's burden to show that no reasonable jury could so conclude as to any of the statements on their own or in combination. That they simply cannot do. Let's begin with the culmination of their scheme. Ms. Sangmong Raj sending a board deck, a 50-page plus board deck with an agenda that she knows is never going to be presented, that she knows is never going to be used.
How is that a misrepresentation, forwarding a deck?
Because it is a representation that, one, she understands that it's going to be used. What she says in the cover email that she then distributes to the entire board is that those are the materials for tomorrow's board meeting. And she knows full well that that is not what those materials are going to be used for. So that's the culmination of the scheme. That is the clear...
Is it that she knows full well that those materials will not be used for that purpose, or that it didn't also include, by the way, we're going to seek to fire you?
It's that she knows, and their plan at that time is that not a single word contained in that board deck is going to be used. And to be clear, this case is
And
not...
is that what happened?
Yes. Not a single word used in that board deck was used. None of the topics on that agenda were discussed. They enter the meeting, and I want to be clear. Defendants want this case to be about the termination of Mr. Masumi. That's not what this case is really about. That's one element of our damages, one element. It is just a small part of our case. Our case is about the stripping of Mr. Masumi's control over this company that they planned for months to happen at this board meeting. That was their plan. That was their plan as of August.
I mean, Mr. Masumi did not have more than a majority control of this company. And there were ways he could have gotten that, but he didn't. Didn't they have the right, if they thought that there was a problem with Mr. Masumi's running of the company, to have done this without giving him advance notice by the way, we're going to discuss this at the meeting, so that he could do something to avoid that? I mean,
So Justice Kapnick, I think you're raising a factual question and a legal question. I'd like to start with the factual question. It is a dispute of fact whether or not Mr. Masumi had control of the company before the board meeting. We say that he did, and our primary support of it is defendant's own words. Dr. Karaz says as early as August of 2015, a potential leadership change seems to be, this quote, seems to be the only scenario in which permanent control does not rest with Cyrus. That's Dr. Karaz's words. That's one of the defendant's words. Ms. Sangmong Raj, after the events, quote, the only way founders and management team could remove him was to remove him without notice. That's R129. R128, Mr. Ganju. So to be clear, I'm talking about all three defendants who say this. Mr. Ganju, in a right of confession to himself, the title of the email, why it had to be a surprise. He says, because all you have to do is accept the charter changes to as of Mr. Masumi, and that they wanted to hire him back. So they are saying that he had control. All three of them say that he had control. So it is at least a fact question. That's first of all. On the legal question, the record doesn't show all of the different ways that they could have tried to terminate him without the scheme that they orchestrated. What they can't do under the law, under New York law, and even under Delaware law, though we're in New York, this is a New York company, this is fraud committed by New Yorkers. I don't know why we're talking about Delaware. Under New York law, you cannot lie to somebody no matter how noble your intentions might be. That's fraud. Why is it fraud? Because one man's Robin Hood is another man's bandit.
I
You don't get to
know
decide.
you take issue with the sounds good, email, but, what's fraudulent about that? I mean, it's like a generalized response. It happens all the time. That's like equivalent to like, okay, so, what's wrong with that?
I'd ask the court to look at what he is saying sounds good in response to. What Mr. Masumi said is that he wants to, quote, focus our board meeting on November 11th on marketing and product. So he is saying the board meeting is going to be about these topics. That's what I think we should do. And he asks Dr. Karaz, please let me know if you have different thoughts about the topics we should cover. And it is because of those questions that it makes the sounds good
You're saying that he has an obligation to say something? other than sounds good? What obligation does he have to say anything else?
If he has a present intention, which he is demonstrated to have a week earlier, he emails internally. A week earlier, he emails internally that at this board meeting, we plan to terminate Mr. Masumi and we plan to do different corporate governance changes.
So you're saying that's the material misrepresentation that leads to the fraud?
That is one of the material misrepresentations. It's part, on its own, that is a freestanding basis for the claim. The dry runs that go on for months where they rehearse a board meeting that they know is never going to happen, that's another part of the claim. And then it culminates with Ms. Sungmung Raj's communication on the evening of November 10th.
I just want to make sure your claim is that they didn't tell, that the material misrepresentation that they made was an omission of telling him that they were going to fire him before the board meeting?
That is at the board meeting.
That's what I'm saying. That's you're saying the material misrepresentation?
No, we're saying that.
What are you claiming is the material misrepresentation?
In which part? In the sounds good email
It's
or
a
all of
fraud. What is your fraud claim, right? Material misrepresentation, reliance, damages. What is the material misrepresentation?
Material misrepresentation is that the board meeting is going to cover product and marketing only, and that they engage.
Only? Where does it say only?
In the board deck that they then circulate on November 10th, and in the board deck that they practiced for upwards of a month, where they
So in essence, you are saying that they had to give him notice then, that they were going to terminate him.
It's not a question of notice of termination, Your Honor. It's a question of once you start talking about what's going to happen at the board meeting.
They had to say, well, wait a minute, this may happen, but something else may happen too.
Yes, because of the nature of their statements, because of the dry runs in which for years, Mr. Masumi had put in place a set of meetings as to which there would be no surprises that came out of those board
So
meetings.
that's how they did it in the past, and by not doing that, that was a material misrepresentation, or at least one of the material.
Yes, because the conduct, because as they sit there and there's record evidence, R1010 from Ms. Sungmung Raj's deposition is one
How
part.
did he rely on that adversely? Because then he didn't buy whatever stock he needed to buy to become a majority owner?
Yes, that is the main way in which he was not able to defend himself. He also could have, that's one way, Your Honor. The other way is if he had just picked up the phone and fired Mr. Ganju, he would have had his control forever, and then he could have exercised his options at his leisure.
Thank you, counsel.
Thank you.
May it please the court, Chris Cariello for respondents. This case is about attempting to turn omissions, that is, not telling Mr. Masumi something, into misrepresentations. The problem with this case.
Well, why was that not a misrepresentation that they send out a deck, said this is what we're going to talk about? They said sounds good, and that really was not what they were going to talk about. That isn't that a misrepresentation?
So several reasons, Your Honor. The first reason is Mr. Masumi is driving every bit of the development of this presentation. It's a management presentation. This is not, they're not talking about board business. They're not talking about Mr. Masumi's leadership. Mr. Masumi says, we need to give a presentation at the board meeting. Here are the topics. That's all driven by Mr. Masumi. He develops every single bit of what they're going to talk about. He's the one who says.
They have an obligation to tell him that they're intending to remove him as CEO.
They absolutely have no obligation.
They have no obligation, right?
Under Delaware law, it is well established. Under the Clausen case, they don't. Under ZocDoc's bylaws, there is no dispute here. They had no obligation to tell Mr. Masumi that they were going to remove him. Every bit of this case is an attempt to skirt that reality. But everything defendants were doing, everything that Mr. Williams is talking about, is just defendants doing their jobs as employees. This is a really key point in this case. There are dual roles. So all of the defendants.
So it's really, let me get this right. It's really plaintiff that's driving what's going to happen at these meetings, and the defendants just seemingly okaying it. That's different than the defendant saying this is what's going to happen at this meeting, and they know materially that is not what's going to happen.
Absolutely. So if the defendants affirmatively came in and said, here's everything we're going to talk about at this board meeting. We have set the agenda, and here's what it's going to be. Maybe we have a different case. We can talk about something.
Isn't that what they were saying, though, with the sending of the deck?
No, because the sending of the deck, and this is, again, undisputed. This is at At R1294, Masumi was asked, why did Ms. Samrangraj send the deck? And he said, because I asked her to do so. It was her job. The agenda that was in the deck was created and set by Masumi a month before this, when it is not yet a solid plan to go forward with initiating a leadership review. He comes up with the agenda. Nothing about that agenda changes. So Mr. Williams and Masumi.
So Masumi's argument is that they should have taken that deck and added in a slide, and by the way, we are intending.
Every single way this argument works, really what they're saying is that defendants had to affirmatively come and disclose something about what their plans were. And the really key point there is these dual roles that I was starting to talk about before. Defendants are employees, so they owe that duty of obedience to do what they're supposed to do as employees. They are also directors, and that duty, their fiduciary duty to the company, doesn't run to Mr. Masumi. It runs to what they think is best for the company. And so when they're doing this management presentation, the notion that they have to say, okay, you have set marketing and product here. This is what you want to talk about. We will do our jobs, but at the same time, we're going to tell you, look, as board directors, we're going to affirmatively disclose that we think there's something else that is in the best interest of the company. Makes no sense. And the trial court recognized this. What they did is the only way they could have discharged both of those responsibilities. They did their jobs. They followed Mr. Masumi's directions. They didn't lie. And they simply did not disclose to him, as they weren't required to do under Delaware law, under ZocDoc's bylaws, that they were also going to take a different step in the best interest of the company before the board. Your Honors, it is understandable that Mr. Masumi is upset about being ousted here. He could have brought an action in Delaware under Section 225, and he could have tried to challenge that and called this inequitable. He didn't do that. What we have here is an attempt to build this backdoor New York fraud claim 5 years later, and the trial court recognized that Mr. Masumi had every opportunity to take discovery and try to find somewhere an affirmative misrepresentation about a particular topic. He took that discovery. He found no evidence of fraud.
Is ZocDoc, ZocDoc said Delaware Corporation.
Delaware Corporation, correct.
So it could have gone under Delaware law.
Oh, absolutely. That would have been the right thing to do here, is to say, I've been wronged immediately, and to come in and challenge that in Delaware. Didn't do so, and then 5 years later decides, let me try to bring this lawsuit in New York under fraud. And the problem is, there's no fraud because there's no misrepresentation. That's what the trial court held, and that should be affirmed. Thank you.
Thank you, Your Honors.
So tell me, how do we get around the Klassen case? How do we get around that?
By looking at the Backer case, which is a subsequent Delaware Supreme Court decision. Backer says that affirmative statements are not cleansed of their deceptive conduct and their deceptive quality just because the person making that deceptive statement believes that they are doing so pursuant to their fiduciary duty. So that's what the Backer case says. It's on all fours with this case. They made affirmative misrepresentations because they wanted to fire the CEO and they didn't want the CEO to know. Well, Delaware law says that that still amounts to inequitable conduct that's punishable by Delaware law. It's also fraud under New York law.
Here?
Sorry, what?
What's the affirmative deception here?
It is sending out the board deck with a entire agenda, an entire presentation that they know is not going to be used at all, is never going to be used.
So it is your purpose. I'm sorry.
I'm sorry. Who prepared the board doc? Your adversary suggests that your client prepared it.
No. No, they all prepared it together. Mr. Masumi was the CEO. Right. Dr. Karaz is now the CEO. He has been ever since the coup, but he was the chief operating officer and he was the president. Ms. Sungwon Raj was the chief financial officer. They all did this together. They were all on the board together. They sat in that room and they hashed things out. I'd ask the court to look at Ms. Sungwon Raj's deposition, R1010. She's asked, and did you discuss the draft board materials with Mr. Masumi at these meetings, at these dry run meetings? Answer, everyone who was there discussed them.
But that argument presumes that they have an obligation to tell you that they are intending to do a board shakeup and essentially and remove you.
I'm glad you asked that question, Justice Scarpula.
I wish I was Dr. Scarpula. I'd make a lot more money.
Sometimes we all wish we'd gone into a different field. Justice Scarpula, I want to be very clear. We are not saying that they had an obligation to tell them that they were going to fire him. That is
Then
not our
what
case.
is the material misrepresentation?
Because once they start talking to him about the board meeting, they have an obligation to be truthful about the board meeting. If they were doing this at some other time,
So
I don't know
by
whether
saying this is going to be the agenda, and in fact, that was not at all the agenda, that was that was part of the material.
Exactly. I'm not saying
That doesn't hurt you. That's not actionable. The fact that they didn't discuss the deck doesn't, you didn't rely on that and were not damaged by the fact that they didn't discuss the deck. You were damaged by the fact that they fired you.
Right.
I mean, not you,
but
your client. So that's what I'm saying. That, how can that be a fraud claim?
because they are telling, I believe it is a direct affirmative
So
misrepresentation.
that
about what's
is
going to happen
exactly
at
it.
the
You are
meeting.
saying that they had an obligation to tell you they were going to fire you. That's the only obligation that would have hurt you.
No, they have an obligation once they're talking about the board meeting to be truthful about what's going to happen during that board meeting.
So that, okay, that's a nice way of saying, that's a fancy way of saying they had to tell me that my job on being on the line was on the agenda. You can phrase it in any way you want, but that's the only thing that would cause you damage. The rest of it, whether or not they discussed the other board slides, that doesn't cause you damage at all.
It's a classic, at least it's a classic half-truth, Your Honor, to say that the board meeting is going to cover topics A through C, and in reality, it's about X, Y, and Z. It's about a completely
That
different
isn't
thing.
what damages you. What damages you is the fact that you're saying the thing that damaged you is they didn't tell you about that they were going to do this board shake-up review and remove you. And that is the question, whether they had an obligation to do that. You don't have to tell, I don't have to tell you my personal information, how I feel about you. There's lots of things that someone doesn't have to tell anybody
Right.
else.
And they were under
So
no
your argument, you're trying to couch it in a different way to avoid the fact that you are arguing that they had an obligation to tell you.
I disagree profoundly, Justice Scarpula, and I wish I could convince you of that. But they could have fired him at any point in time. We are not saying that they could never fire him. We are saying that once they start talking about the board meeting, once they're talking about the agenda for the board meeting, once they send him an agenda for the board meeting, that is an untruth, that is a deception, when they know that that is not what's going to happen.
That deception didn't harm you.
Yes, it did.
How?
Because they lured him into not being able to defend himself.
Because they didn't tell him that they were going to fire him. Not because they gave him a deck that they didn't go on, because they omitted information. You're saying they had an obligation. Again, I guess we'll go back and
It makes the statement
Right, you're
untrue, and it's undisputed in this record, and we have their own words saying it, that he could have taken the steps to defend himself by firing Mr. Ganju or by exercising his options that would have at least maintained his control over the company.
How come he didn't exercise his rights under Delaware law right then? He could have done that, right? And that would have avoided this whole issue.
I don't know whether or not it would have avoided this whole issue, but he has rights as a New Yorker to bring a fraud claim in New York within the statute of limitations, and that's what he did. As to, I want to conclude with one important point. Of course, I will answer any other questions that the court has, but I know that we've been going on for some time. In the 8 years that Mr. Masumi was the CEO of this company, no internal director raised any question in any board meeting that he and the other internal directors were not aware of. They all, in every board meeting, knew what was going to be discussed from alpha to omega. The only exception that anybody in this record was able to identify was that Mr. Masumi decided to give Ms. Sungwon Raj a surprise grant of options. The only time that any internal director did not know everything that was going to happen in this board meeting was a gift that Mr. Masumi, with the agreement of other directors, decided to give to Ms. Sungwon Raj. His reliance as to what was going to happen in that room, and that's the extent of our claim, that he was entitled to know what was going to happen in that room, is perfectly within the bounds of New York law, and summary judgment should not have been granted to defend.
Thank you. Berlotta versus A.O. Smith Water Products Company.
Good afternoon, Your Honors, and may it please the Court. My name is Heather Janiskaw with the law firm Siegel McCambridge, representing the appellant American Honda Motor Co., Inc. For ease here, I'll refer to my client as American Honda. At its simplest, this case involves a witness who failed to offer evidence of asbestos exposures from a product sold or distributed by American Honda. Respondents' claims are based on speculative testimony from a witness who affirmatively testified that he could not say what his brother did.
What about the brother who testified that that he worked sometimes at this same repair shop in Staten Island, right? And sometimes while his brother was working, that he saw him working on the cars, and that some of those cars were Hondas. Isn't that enough, at least, to have that basic information?
No,
To avoid this motion to dismiss?
No, Your Honor, that's not enough here.
Why not?
The witness, Thomas Barlotta, worked with his brother for those 2 years at the Staten Island shop after a part-time after school. He testified that he pumped gas, and on occasion, when he had time, he would go and help inside and do whatever miscellaneous tasks. He described work generally on cars that came in, and then each of the defendants then came in and cross-examined him and asked for more details as to the work that was performed on their products. As to Honda, and I was there for the cross-examination, he was asked what he could recall about the Hondas that came in, the work that was performed. His personal observations that he had, that they didn't have a lot of Hondas come in. He didn't do much but take the wheel off. I would usually take it off, and then they would go from there. Beyond that, he could not remember anything more than a small four-door sedan. He thought it was an Accord. He said, quite frankly, it wasn't that interesting. And he said he did not want to say I didn't care, but I didn't rush in to watch him work on that car. He could not offer anything beyond taking the wheel off of the Honda vehicle and walking away himself.
So how do we look at pages 342 and 343 of the record, where he talks about assisting the decedent with the brakes? He's very detailed about, the brakes.
If I'm not mistaken, Your Honor is referring to his general testimony as to the work performed on any number of cars that came into that shop. When he was cross-examined by different manufacturers' representatives, myself included on another client, he had more details. He could describe the work that was being performed on such and such vehicle. We did this, we used this part. He had more details. But in the instances of the Honda vehicles, his testimony, he said specifically as to Honda, I don't know, because he walked away after taking off the wheel. He can assume, and as we all can, we can assume every crack of the bat means a home run, but you don't see where the ball is going, you don't know. He did not see what his brother was doing, and he specifically testified to that fact. And under the case law of
352. So you can't tell me sitting here today what work you did on the Honda. I can tell you he did brakes, and he goes into various things.
Well, he said at that point,
Because he assisted him with the brakes.
He did brakes, and then, but in terms of the work he did on brakes, you don't know what he did? Specifically, no, not on a Honda. And he had previously described numerous tasks that were performed at that shop. It didn't necessarily need brake replacements. There were numerous items that he would go in and assist on at time. So when we were afforded the opportunity to cross-examine him, he had no details to offer as to the work. He could not speak to his brother performing a brake replacement.
Well, is there any doubt that Honda's brakes had asbestos?
Well, first off, there's also no testimony that...
Let's start with one thing. The brakes have asbestos, right, at that time?
At certain points of time, certain cars and trim levels of cars had asbestos-containing brakes.
So if you're working on brakes and brakes contain asbestos, isn't that enough to get you to a jury? You can argue whatever you want to the jury, but on a motion for summary judgment, isn't that enough to at least get you to the jury?
However, the witness here could not offer the work that was performed on brakes.
He said he worked on brakes.
Yes, but there were multiple tasks.
He didn't know whether he used what specific works. But I'm saying, isn't he worked on Honda brakes. Enough?
Well, he never said he worked on Honda brakes. That's another item. No, when asked, what did he do? He did brakes. Well, can you tell me what he did? Specifically on a Honda? No, I cannot.
When asked who manufactured the cars that you and the decedent were doing the brake work on, he responded, we worked on almost everything, and we would get some Hondas. That's not enough?
No, Your Honor, that's not enough, particularly as he described multiple tasks that were performed on the cars,
So you're
on
saying
brakes.
for it to be enough, he had to specifically say that he saw his brother working on Honda brakes?
Yes, Your Honor, under the case law in Zuckerman, Cowain, Silatex, unless he can say that.
Well, maybe that might not even be enough, because you just limited
Right.
your admission about asbestos in the brakes to certain trims and certain models. So maybe it had to be more specific.
Well, I would request that there be detail sufficient as to the work that was performed.
Well,
if
saw
he
his brother
said
working on brakes, and they knew that they worked on Hondas. You're asking for another connection, which is, I saw him work on Honda brakes.
I saw him perform a brake replacement on a Honda involving a Honda brake.
You can follow up on rebuttal, counsel.
Thank you.
I always have to adjust it way down. Good afternoon. Meredith Abrams of Whites and Luxembourg for the respondent.
Counsel, why is it what your adversary is saying or sort of implying that's required to make that direct connection? Why is that not necessary?
Couple of reasons. First of all, I think the panel recognizes based on the questions you were asking that direct connection is made. Mr. Barlotta clearly testified, I saw the work he was doing. I was, at many times, inside the shop working with him. I was holding the parts he was using. Even when I was outside pumping gas, I could see what he was doing. So the idea that this testimony is speculative is just doesn't pass muster. The testimony was clear and
Well,
But
that
is it a
testimony- I'm sorry, go ahead.
Well, is it a problem that he didn't see exactly the kind of work he was doing? He just said, well, he worked on some brakes, and that sometimes some Hondas came in. Did he have to say, as your adversary suggests, that I saw him working on certain aspects of the brakes on a certain number of Hondas? You haven't had to make a better connection. Is there enough connection here to avoid the summary judgment motion, which is what we're all talking about?
There is, yeah. And I think if you look at all of the cases we've cited, the various on-point asbestos product ID cases that Honda largely ignores in their appellant brief, but Nee, DeSalvo, Reed, Calermos, Kroc, all of these cases involved connections between the decedent or plaintiff's work and the product that were far more attenuated than what is testified to by Mr. DeSalvo here. For example, in Nee, the decedent testified that he worked with gaskets at Brooklyn Navy Yard. There's no more detail about what kind of gasket work. And there were other individuals who were working there at similar times saying Goodyear gaskets were on site. That was sufficient to avoid dismissal.
Amongst other gaskets.
Amongst other gaskets, exactly, yes. Or you look at Reed, in which the court said the plaintiff is not required to show the precise causes of his damages, but only to show facts and conditions from which the defendant's liability may be reasonably inferred. This is particularly true on defendant's motion for summary judgment, where plaintiff is required only to show the existence of triable questions of fact, and any doubts must be resolved in favor of the non-movement. And Reed actually references the Kawine case that Honda relies on and says that in those, this case law is not in opposition to Kawine, because in Kawine, the only testimony linking the plaintiff to the product was that there may have been bags of the product on site that may or may not have been opened, and the plaintiff was on site at some point. This is far, far, far more attenuated than the testimony we have here, which is specific. And as to Mr. Barlotta not describing the specific work his brother did, I don't think that is an accurate characterization of the record. If you look at page 139 to 140 of the record, Mr. Barlotta, testifying generally about the brake work his brother did, talks fairly specifically about sanding it with an emery pad. He talks about how much glaze would be left when a brake needed to be replaced and how the sanding would go through the glaze to the asbestos insulation, and that would create asbestos dust. He talks specifically about how the first thing you would do on any brake job is use compressed air to blow dust out of the brakes, which created asbestos dust his brother breathed in and exposed him to asbestos. And a final point I want to make, because I know I'm running out of time, they are the movement here, and it was their burden to prove that their product could not have caused Mr. Barlotta's cancer. They could have submitted product manuals, invoices, any kind of evidence at all saying Honda wasn't selling asbestos brakes in Staten Island at that time, or excuse me, in Long Island at that time. Honda, was making 99% non-asbestos cars. They could have tried to depose somebody else who worked there at the time and who would testify, no, there was no asbestos exposure, no, we didn't do brake work.
But we didn't work on Hondas.
Exactly. They provided no affirmative evidence whatsoever. They did not meet their burden, particularly if you look at cases like the ones we cited, in which defendants did, in some cases, cite affidavits from people at their companies and other sorts of evidence saying we didn't make this kind of product or this product wasn't on site at the time. And even in those cases, that was not enough to get summary judgment, because you just need a bare showing if the prima facie burden has been met, which it is not here. But if that burden is met, the non-movement just has to make a showing from which reasonable inferences can be drawn that there is a question of fact, and we have more than done that here.
Thank you very much.
Thank you very much.
To briefly respond, again, Respondents' Counsel cites to parts of the record talking about the work and the details. This was all done generally. Thomas Barlotta did not observe the work with the Honda. He could not describe what happened when he walked away. He didn't perceive those tasks that could have been performed, the parts that could have been used, how long any of that work would have taken. These facts are not enough to satisfy under New York law and do not.
But that may be ultimately true at trial, but how did you meet your burden of showing that plaintiff could not have been working on the Honda brakes at the time that he had the asbestos exposure?
Well, at this point in time,
So what you're saying is the plaintiff has a lot of gaps. I mean, that's a great argument for a jury, but that's not enough to meet your burden. How do you meet your burden?
This is more than just gaps.
Well,
and
okay,
it's
so
more
tell me
than
what you
speculation.
submitted. Tell me
there
what
would
you
be no-
submitted to show that there was no possibility that this plaintiff was working on asbestos-laden Honda brakes.
It would be a near impossibility to
Oh,
respond.
I disagree.
well,
We get lots
well,
of
in an
cases where manufacturers say, I had nothing to do with this and this place and that place. So all you did was plaintiff didn't say enough about his exposure to the brakes. But that's not enough to meet your burden.
American Honda could have responded with manuals or documents such as that if the vehicles were identified, the parts were identified, the tasks were identified. But none of that was made clear in the testimony of Thomas Barlotta. He had testified that he performed the work by removing the wheel and walking away.
Have you spoken to anybody else at that gas station?
No other witnesses were offered. No other documents were offered.
Couldn't subpoena. You have subpoena power. You know where the place is. This is your burden, your case.
However, we feel that plaintiffs have not made their case and
But of
put
course,
evidence
it's
in
your
the record.
motion. It's your summary judgment motion, so you have to, you have the burden on that. Maybe they won't win at trial. I don't know, but that's not what the burden is here.
Thank you, counsel. Thank you. 1946 Tremont 1B versus Nowell Realty.
Well, almost good evening, Your Honors. Christopher Volante for the appellants in this case. In this case, we argue that the order of the lower court needs to be reversed. There are several issues with the lower court's decision here. Obviously, most first and foremost on our position is that our position has to be that we were not a party to the prior foreclosure action. There was no valid lis pendens at the time. We're the only owner that owns the property at that time. So with that, due process would say, you can't take away my title if I'm not a party to that action.
So you had title through a condominium lien foreclosure procedure.
Correct.
Right. And you knew that when you your predecessor got that got that deed, that it was subject to a mortgage. You knew it was subject.
I actually want to make 2 points on that, if I could, Your Honor. First of all, to correct the record a little bit, there was a condo lien foreclosure that led to a deed to our predecessor,
right,
and then a deed to us.
That was West Fork, and then it went
Yes.
to you. Okay.
And then, so I just want to make sure that we didn't take it at the condo lien.
No, I understand that.
And then the other is, and this is something that I think a mistake that the trial court made as well, and my adversary makes in their briefs, is that they're conflating an interest, a purchaser being subject to a mortgage and being bound to a foreclosure action.
So the foreclosure action started later, after you had already.
No, the foreclosure action had been had started before we took the deed, but there was a gap in the lis pendens,
right?
And we were never joined to the action as well.
I have a question for you.
Yes.
You know, because you're the movement, how did you establish that, not you, your client, right?
I understand.
You know, lacked actual notice, you know, of the foreclosure, you know, action at the time of conveyance?
Sure. Well, there was certainly, I don't know that it's our burden to prove that we didn't have actual knowledge, but certainly the plaintiff didn't put anything forward that we had actual knowledge other than speculation. You know, there's definitely been, I believe in the record, the representation that there wasn't actual knowledge. It certainly wasn't constructive knowledge. And also this goes towards notice of pendencies and lis pendens law in general, which is, what are they for if not to ensure that you have to have a valid lis pendens in order to bind somebody to an action? There'd be no point.
Was the mortgage recorded?
The mortgage was recorded, I believe.
So anytime anyone did any search on that condo, that mortgage would have come up, right?
Well, you knew about the mortgage.
You knew about the mortgage.
Well, I can't
So
say-
they knew
I can't
about
say
the
that-
mortgage. You just didn't know about what the claim
Right,
is.
and the thing
you didn't
is,
know about the foreclosure.
we didn't know, right, there's no actual knowledge of the foreclosure action. That's Polish National, the most famous foreclosure case that exists. And also it also to extend the idea that there's an open mortgage and therefore we are bound by a foreclosure action ignores all the case law that we even cite in our own brief about when there's an expired or canceled lis pendens, there is no duty on the purchaser, therefore, to further inquire as to the status of any action that might be going on.
The court did not grant you summary judgment, but they did grant the defendant summary judgment, and they also allowed the defendant to add a counterclaim
For re-foreclosure.
or a re-foreclosure.
And that's actually one point I want to make as well in the kind of somewhat illogical nature of the lower court's ruling here, is that if there's re-foreclosure and strict foreclosure also, open claims, that essentially in and of itself means our interest in the property hasn't been extinguished. We haven't had our
So
opportunity.
they shouldn't get summary judgment.
They certainly shouldn't get summary judgment on a counterclaim that says they're the sole owner of the property, which is essentially what the first counterclaim was, which is a declaratory judgment that they're the rightful fee owners of this property.
Fair enough, right? They were going to have to prove something, but there's enough in there that you shouldn't get summary judgment.
Well, of course,
right?
I would disagree with that.
There's
but
enough
certainly-
in
If they
there.
don't get it, you would take
Right,
it.
certainly, I would say at the very least, no one should have got summary judgment
Okay,
here.
fair enough.
Yeah, and I'll save the rest of my time for rebuttal.
Thank you.
Good afternoon, Your Honors. May it please the court, Eric Mandel for the respondent, Nawal Realty.
So what do you say to his, sentence that nobody should get summary judgment?
Well, I completely disagree, not surprisingly. This case involves long-standing real property principles. The fact is, when his client took a deed to the property, there was a mortgage of record. That gives rise to a duty of inquiry. Had they so inquired, they would have discovered the existence of the foreclosure proceeding. Therefore, they are bound by those proceedings.
So remind me again, the foreclosure proceeding started before they took the deed?
Correct. The foreclosure proceeding was commenced, there were two foreclosure proceedings.
Right, I know that. There was his foreclosure proceeding, and yours was the mortgage foreclosure.
and
His
my-
was, I don't know, the lien foreclosure.
My mortgage foreclosure proceeding was commenced in June of 2012. There was a notice of pendency that was filed contemporaneously with the commencement of that action. His deed, the notice of pendency expired by its terms 3 years later in
Right.
June of 2015. There's no dispute that that happened.
Right.
His client took a title in November of 2015. The mortgage was still of record.
The mortgage was always of record. I
Correct.
get it. He knew about the mortgage. He knows he took his deed subject to the mortgage. The question I keep going back to is, did they have notice of an actual foreclosure proceeding? And the problem is, it's almost like a law school question, like how could these facts really have happened? It was during the time when you admit that there was no notice of pendency, that if they had looked, they wouldn't have found a notice of pendency because it had lapsed.
Yes, but they had a duty to inquire. They see a
What
mortgage.
were they supposed to, just because there was a mortgage, they have to say, hello, is there a mortgage
They need to go to the clerk's office. They need to go to the land records in the clerk's office, and they need to see that the mortgage had a borrower's name that was different than the grantor that they acquired title from. That gives rise to a duty to inquire what is going on with that mortgage.
They couldn't have just sold, they could have sold it to someone, I mean.
No, the borrower couldn't have sold. The mortgage that was being foreclosed was made by the individuals who had previously owned the condo.
Right.
Jose Bonilla.
Right. And that went to that's the one that went to.
No, that common charge was foreclosed. They owned the property. There was a common charge foreclosure.
Right.
And the referee within the common charge foreclosure conveyed title to West Fork.
Right.
And conveyed title to.
I got that.
They see the name Bonilla is different than the grantor on their deed West Fork. The mortgage that they have notice of is in the name of the individual underlying borrower. That gives rise to a duty of inquiry. If they search the records, they see that there's a mortgage foreclosure proceeding pending, and they are therefore bound by those proceedings. The law is beyond clear that this is the case.
No, it has to have actual knowledge. So you don't get summary judgment because you haven't proved that this party has actual knowledge. Actual knowledge is what you have to prove. That's what the law says. Not, I was on notice. You have to prove that you have actual knowledge. So all you've said so far is that they had a duty to inquire. I don't know what that duty, where that would have ended in my duty. Maybe I would have inquired, and because you didn't file the list pendants and you let it lapse, maybe that wouldn't have shown that your foreclosure action. We don't know, and you haven't proved it.
It's actual and/or constructive
I mean,
knowledge.
you're sitting here arguing. You're the one who let your lease pendants lapse.
Well, it wasn't yours. It
Your
really
Honor,
wasn't his.
Okay, the list pendants.
Your Honor, it's actual and/or constructive notice.
It's not.
Constructive notice they would have had if they had looked at the records and seen the
And
mortgage.
just seen a mortgage, that doesn't give you constructive notice of a foreclosure.
It most certainly does.
And can I
I think
just
the case law that we cited, including a First Department case in our brief, is if not directly on point, it's very persuasive.
If you have notice of the mortgage, you're saying a fortiori you have notice of a mortgage foreclosure? I have not seen a case that says that.
You have a duty to inquire.
You have a duty to inquire, but you haven't shown what the duty to inquire would have shown.
It would have shown the pending foreclosure.
How did you prove that? What did you put in?
The court can take public notice of that fact. There's a pending foreclosure
Have you ever
proceeding.
looked at a mortgage? Have you ever looked at a title search?
I do.
Do you know how many times title searches don't come up? You have to show. You have to do more than say, everybody knows that that's right.
But it's in the clerk's records. They have a duty to go to the clerk's records, type in the name, and it would come up.
Thank you,
That's how-
counsel.
Counsel, can you explain to me the counterclaim that they want to, that the court permitted them to and that's part of this appeal.
Right, so the
was
counterclaim that was
for
granted
the
to
fo-
them.
was for a re-foreclosure.
No, so that was to amend their answer to include a re-foreclosure.
Right, and then they would have to start a re-foreclosure
As part of their
proceeding. But
counterclaim.
you would be named.
Correct. That would be one of the counterclaims that's still open. They also have a strict foreclosure one that we argued should have been dismissed because they didn't even try to defend it on summary judgment. But beyond that, what was granted by the court, and then I want to quickly respond to some of my colleagues' comments here, was a declaratory judgment under RPAPL 15011 that they are the fee owners of the property with a superior interest to ours, which is diametrically opposed to a re-foreclosure claim. Because the whole point of a re-foreclosure is we weren't bound by the prior action, and we now either need to give you an opportunity to redeem, or then your interest will be extinguished.
You're not going to redeem. You just want any.
Want some money.
Money.
Well, I wouldn't say
If
that.
there's any
We have the
left.
property. We still have the property. But I do want to quickly respond to some of the things that my colleague said. First of all, with regard to the fact that the argument that we're bound by the prior proceedings. Well, again, then why would you start a re-foreclosure? Those two are diametrically opposed.
Well, because they want to make sure that they're covering all their bases, because in case they lost, then they could do a foreclosure.
Certainly. I also
right?
want
So
to quickly
that's why you
comment
would do
about
that.
the idea of constructive notice that was brought up. That's what the Liz Pendens is for. That gives you constructive notice of the action.
I don't disagree that you're on at least inquiry notice, but I do agree that you have to show what the inquiry notice would have shown.
Right, and the
it's
duty
not enough to say everybody knows that.
And there's certainly case law that we've cited for the proposition that the purchaser is entitled to rely on what's in the record and has no further duty to inquire when there is a lapse or canceled Liz Pendens. And the last thing, if I can just end on a quote from Herman v. Cabinet Lamb from the Court of Appeals, 1916, an old case, but certainly still good law. Judgment of foreclosure in which the owners of the equity of redemption have not been served with process or do not voluntarily appear is absolutely without jurisdiction as against such owners, and the purchaser at the sale under the judgment derives no title whatsoever.
Thank you, counsel.
Thank you.
We're done. Thank you, Your Honor. Thank you. Robeson Sarmiento v. Method General Contractors.
Good afternoon, Your Honors.
Good afternoon.
Jack Watkins from Kahana Feld for the appellants. I understand it's a very late hour, so I'm going to keep my remarks here as brief as you'll allow me to. Really, the only issue that has survived the settlement with plaintiffs in this case is the impact of a default by a defendant on that defendant's ability to prosecute third-party claims. And I think that we have shown in our brief very comprehensively that because a default is not a adjudication on the merits, we should be allowed to prosecute those third-party claims.
Do we even have to make a decision on the aspect that involves the plaintiff, the default? We really don't, because you filed there's a stipulation of settlement between you as the defendants and the plaintiffs, right?
Correct.
So now the case is just you against a third-party defendant.
Correct. And at the beginning of our reply brief, we cite the Belluccia case, which is a case that this court decided a number of years ago. I was involved in it. And in that case, this court held that the settlement of the underlying action did not moot or take away the ability to pursue indemnity claims.
Right. So you have indemnity claims, contractual indemnity claims against the third-party defendant.
That's correct.
So the thing is, did you default on those also, or those weren't even?
No, the third-party defendant was not joined in the action at the time of that default.
So the third-party claims were just dismissed because the action was dismissed, right?
The third-party claims were dismissed. So what happened was, after the default, there was a motion to vacate the default that was denied. Counsel in the motion court tried to vindicate their client's rights, which is their duty. They made a re-argument motion and a renewal motion serially. At the same time, while the default was out there, but before they recognized there had been a default, they'd served a third-party claim.
They what?
They served a third-party complaint.
So what was the basis of dismissing? What was the trial court's basis for dismissing the third? I thought it was just because the action is gone, the third-party complaint?
Not exactly. Method maintenance, the third-party defendant cross-moved to dismiss the complaint on the basis that because of the default, in a default, you're deemed to have admitted the traversable allegations in the complaint. So because one of the allegations in the complaint was my clients were negligent.
But that would be wrong anyway, right? Because you have more than just, you could be partially negligent and still have an indemnification claim.
100%. It does allege that we're the
Wait,
sole
wait,
negligent
so
party.
so I thought the court just dismissed the third-party complaint. Oh,
No, it was subject to a cross motion that we opposed.
okay. Okay.
And the cross motion is a little vague. I actually looked at it this morning. It doesn't say what part of the CPLR it's moving under. So I would infer if it were me making the motion, I would be making the motion under 3211, 3212 out of an abundance of caution, and
So
probably
you're saying
3215.
okay. All right.
But it actually doesn't say. But nevertheless, the argument is because you're deemed to have admitted the traversable allegations, that means you're negligent. Because you're negligent,
Then you can't have a third-party claim because you're responsible for the whole thing.
Right. And
Why didn't you move to vacate the default on the third-party?
Because the case was, the stipulation just happened last month, right?
right, we settled during the pendency of
Why
the
don't you go back to the trial court and make a motion to vacate your default on the third-party complaint?
We noticed an appeal. We were set down for a damages inquest with the plaintiff. On the eve of the damages inquest with the plaintiff, we settled. This is not exactly dehors the record because we put this in a letter before the court, but it's outside the four corners of the record on appeal. At that point, an effort was made to reach a global settlement that was unsuccessful. We had this appeal pending and fully briefed because we'd expedited that in an effort, as the court knows, to adjourn the inquest. So this seemed like the most economical way to proceed.
But I think my point is you don't get to appeal an order issued on default.
We're not appealing an order issued on default.
Are you not saying that the third-party action was dismissed on the merits upon your default?
The third-party action was dismissed on the merits because the motion to dismiss the third-party action was granted. It was made as a cross motion.
Did you put in papers in opposition to that?
Yes.
It was granted on the merits.
Yes.
Thank you.
I'll further address on rebuttal. Thanks.
I'll ask the other client. I'm sorry.
May it please the court, Christy Kenzeg on behalf of third-party defendant Method Maintenance.
I looked at copies of of Judge Gray's two very short orders. He referred both times to oral argument transcripts. Were they in the record?
No, the transcripts from oral arguments.
Okay, that's what I thought. Okay, so so it says that the third-party defendants. I mean, it's very hard to know exactly what the judge did here because he said he did it based upon the terms of the oral argument, except that we don't have the oral argument, so I don't really know why he
I was
dismissed
under the impression that it was basically dismissed because of the default of the moving party.
So I think the court's order was essentially that it was dismissed based on the default where they've deemed all of the plaintiff's allegations admitted, and so therefore they can't recoup from us.
It's unclear because that kind of decision wouldn't be appealable. The question is if it's on the merits, and the merits are that you have a broad insurance policy that doesn't only, you can get indemnification even if you're partially negligent under your policy, right? So how are you defending that summary? Let me ask you that. How are you defending that summary judgment?
Sure. We're defending summary judgment because this court has consistently held that collateral estoppel may be applied to default judgments. We're here, the party whom preclusion is sought against.
So you're assuming that it's a default judgment, not a judgment on the merits.
I am assuming that it is, yes, based on a default judgment.
Okay, but there's, okay, so this is
messy.
But it's a default judgment based on them having the opportunity to litigate and then failing to appear, and then a court order issuing a default judgment because they failed to appear for 3 court conferences. So that's different than if they did not answer. And so all of the cases that they've cited to in their brief are a default where they never had an opportunity to litigate and appear in the action. Here, they did. They were given the opportunity to show up and litigate all of these issues, and then failed. 2 different counsels for both third-party plaintiffs failed to appear at court conferences 3 consecutive times, and then the default was
I thought
issued.
you weren't even in the case then.
We were not in the case yet.
When did you get brought into the case?
They, October 25th of 2024 is when they served the third-party complaint, and October 2nd is when they were in default.
So the reason why I keep asking this is because if it was granted on default, that's not a judgment on the merits. They can just start a new action. Right? They're in their 6-year statute of limitation. That's not a problem. But counsel is telling me that it was a decision on the merits, which is a different thing. So it's unclear, and because there's no transcript in there, it's hard to know. You're arguing that it was granted on default. Counsel's arguing that it was granted on the merits.
Well, I think there's a way for this to, it was on default. It was based on default that since they deemed every allegation admitted, that's why the third-party complaint was dismissed. But I think that is a determination on the merits.
Thank you.
I'm going to attempt to clarify what's obviously been a confusing topic.
And let me just ask you, if it's if it was granted on default, okay, fine, start your own action. What do you say? Because that's not a merits.
So I need to ask what the predicate for the pronoun it is in that sentence.
What?
I need to ask what the predicate for the pronoun it is in that sentence. So we have several motions here, right? We have our initial motion to vacate the default. That was denied.
The main action.
Yes, in the main action.
Right.
That was denied. There was never a motion to default us. That never happened. The court did it sua sponte. So, because of non-appearance at court conferences. That's correct. We made a motion to vacate the default. That was denied. That is appealable. You can appeal from a denial of a motion to vacate a default. And that was the initial part of our brief. But that was mooted by the settlement with the plaintiff. When we made a motion to renew, to attempt to renew that motion to vacate the default and get the default vacated, the third-party defendant cross-moved for dismissal of our third-party complaint. We did not default on that motion. We opposed that motion. What the court's one-page order does not say and does not explain. I agree it's very short, and it is unfortunate that the record does
The
not.
argument, yes.
It was not on the record. There was no court reporter present.
Good reason.
So, and there should have been, obviously, and we regret that there wasn't. But what the court does is it grants that motion to dismiss. If you read that motion, and this is in our brief as well, nowhere in that motion does the third-party defendant say, here's how we carry our burden to establish that there's no validity to these claims against us.
But it's clear that that cross motion was not decided on default. I mean, that you litigated that part.
Correct.
Because you already had defaulted, you made a motion to vacate the default, it was denied. You made a motion to renew, and that's when she made the cross motion, correct?
Correct. So what my learned friend and I agree on here is that what really happened is that the court said, well, because you defaulted, all of these issues are deemed admitted against you.
And so the third-party case.
Therefore, your third-party action is kaput because you've admitted liability. And we think that that's wrong. That's giving collateral estoppel effect. And while my learned friend said this court has held repeatedly that a default is a judgment on the merits, her brief contains 0 cases that say that from this department. 1 49-year-old case from the second department that this court has never cited that goes against the Court of Appeals, and every single case from this court assembled on page 23 of our brief that goes the other way, all of which are ignored in her brief. So we say that you're correct. We should be allowed to start our own action or to continue under this aegis. I don't care if we buy a new index number or not. But that should not have been given preclusive effect, which is what happened here.
I get it.
And if I can say one more thing, not on the merits, I am so pleased to be arguing a collateral estoppel issue before you, Justice Scarpula, and you, Justice Kapnick, because as you may or may not remember, I had all of those issues on Sebastian Holdings versus Deutsche Bank a million years ago. And that,
Which we both had the pleasure of handling.
Well, to you, it was the annoying case that kept cropping up. To me, it was my entire life for 5 years. So thank you.